The committee of the whole will please come to order. Privilege of the floor, Representative, oh, no, not privilege of the, oh, gotcha. All righty. So the next bill for our consideration is Senate File 164. And do I need a chairman?
Senate File 164 is sponsored by Senator Boner. Public Improvement Contract Requirements Amendments, an act relating to cities and towns. Mr. Speaker, your committee number 7, Corporations, Elections, and Political Subdivisions, to whom is referred Senate File 164 in gross, Public Improvement Contract Requirements Amendments, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Chadwick, Haroldson, Harshman, Knapp, Newsom, Olson, Ottman, Wiley, Yin. Representative Knapp, Vice Chairman.
You have heard the reading of the bill. What is your pleasure, Chairman Olson?
Thank you, Madam Chairman. I move that when the committee of the whole rises to report that it do so with the recommendation that Senate File 164 do pass. I further move the adoption of the Standing Committee Amendment, and I will turn over the explanation of the bill as well as the Standing Committee Amendment to the good representative from House District 62.
Representative Chadwick.
Thank you, Madam Chairman. In the words of a famous former speaker, this is a good little bill. The genesis for this bill comes from a meeting I had with the chief of a law enforcement agency in one of my district's towns. And it turns out when he put out, per current statute, a solicitation for bids in the local newspaper, he almost choked on the cost, got one response from that state southwest of us. One. Not one from our local community, which has multiple dealerships. He was looking for 2 new patrol vehicles and ended up having to go to the local dealerships, talk to those people, and he finally got one of them to put in a second bid. Of course, he's required to have 3 by current statute. He also, the dealer in that state southwest, he was $13,000 cheaper. So what this bill does is address some of those issues that are concerned within that little story. If you've got your bill on page 2, on page 2, you'll see that for public improvement contracts, it ups that limit from $35,000 to $75,000. And then when you turn over to page 3, it describes what happens when the successful bidder is not required to post the bond or other form of guarantee as long as the purchase is under the $100,000. And again, it reiterates that at the bottom of page 3. At the bottom of page 4, it specifically refers to the purchase or lease of a new automobile or truck that is subject to the advertising requirements. These contracts shall not be subject to those requirements. When you get over to page 5, should the city, town, or joint powers board be unsuccessful in getting the necessary bids that they want, then they have an option of soliciting bids, which is what my local chief law enforcement officer had to do. Now, you may see there at the on line 18, it puts that limit at $250,000. And that question was asked, why that number? Just so happens that's what it costs for a transportation bus that you see in many of the cities and towns around the state. They were running about $250,000. So that's the meat of the bill. And at this time, I will move the amendment, which is to change the date of enactment from July 1st to April 1st. And with that, I would call for the question on the amendment.
You have heard the motion on the standing committee amendment. All those in favor say aye.
Aye.
All those opposed, no. Standing committee amendment number 1 has been adopted. We're back on the bill. Question having been called, all those in favor of Chairman Olson's motion that when the committee of the whole rises to report, do so with the recommendation that bill number Senate file 164 do pass. All those in favor say aye. Aye. Those opposed, no. Senate file 164 is passed the committee of the whole. The next bill for our consideration is Senate file 153.
Senate File 153, sponsored by Senator Boner. Election Security, an act relating to elections. Mr. Speaker, your committee number 7, Corporations, Elections, and Political Subdivisions, to whom is referred Senate File 153 engrossed, Election Security, respectfully report, same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Chadwick, Haroldson, Harshman, Knapp, Newsom, Olson, Ottman, Wiley. Noes, Representative Yim. Representative Knapp, Vice Chairman. This bill was re-referred to Committee Number 2, Appropriations. Mr. Speaker, your Committee Number 2, Appropriations, to whom is referred Senate File 153 engrossed, Election Security, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Walters, Zwanitzer. Noes, Representative Sherwood. Excused, Representative Stith. Representative Nicholas, Chairman.
You have heard the reading of the bill. What is your pleasure, Chairman Olson?
Thank you, Madam Chairman. I move that when the committee of the whole rises to report that it do so with the recommendation that Senate File 153 do pass. I further move the adoption of the standing committee amendment, and I will turn over again the explanation of the bill and the standing committee amendment to the very capable representative from House District 62.
Representative Chadwick.
Thank you, Madam Chairman. Okay, this is I'm going to go ahead and call it what I call it. It's a Tisselby. This is a simple little bill. Okay, we've all heard about the issues going on with elections, perhaps not so much in our state, but in other places. We've heard lots of issues. So this bill, I'll just go right straight into the provisions of the bill and what their rationale is. It requires a limited ballot audit. The goal of the audit is to identify and correct any mistakes that would change an election outcome before the canvassing board meets. With that in mind, the statistically significant standard is based on the margin of victory, not the overall number of ballots. The closer the race, the more ballots will be counted. The procedure was successfully administered by the clerks this past election cycle on a statistical model developed by the university, and the 5% limit is based on that real-world experience. This limited time-sensitive audit does not preclude a more thorough audit at a later date. And what happens is when they do this audit, there are numerous people involved. So they have to look at each ballot and then check it with the picture of that ballot on the counting machine. Once they've done that, of course, each ballot has an identifier. So as that identifier is run through the machine, they can bring that ballot up. Do they match? Yes. So they do that for every ballot. Takes approximately 30 seconds to go through that process. And why the 5% number is because of that 30 seconds. In some of our larger counties, it could take up to 42 hours to go through that process. And we talked about higher numbers, 7.5%, 10%, 8%, and decided that the 5% was adequate according to what's already been done. The bill requires an air gap, and I don't know if everybody in here is familiar with what an air gap is, but that isolates the election machines from the internet. In other words, there is no connectivity, and that is known as an air gap. So that is required within this bill. It also reduces the early voting period from 45 days to 28 days, except for those who are covered under the Uniformed and Overseas Citizens Absentee Voting Act. That will remain at the 45 days. It'll reduce vulnerabilities associated with early voting. And 28 days is plenty of time to vote. The national average is 23 days. So we were almost double that previously. This 28 days shortens it up a bit. It requires an election judge or law enforcement officer to transport ballots. It also requires a numbered seal that would detect any tampering with the ballots while in transit. This ensures adequate chain of custody during election day. There is a direct $100,000 appropriation to the clerks for ongoing professional development. This simply acknowledges there is always a need for ongoing assessment of best practices in this evolving important area. We had the representation from those people who run elections in our counties. Much of this bill is at their behest. You can see I guess I should start by saying I move the amendments which are pretty straightforward. There's nothing complicated about them. And at this time, I would call for the question on the amendment.
You've heard the motion on the, oh, I'm sorry, thank you. Chairman Zwanitzer,
Thanks. So we're on the standing committee amendment, right, Madam Chairman?
correct?
Just a little more testimony. So we're taking out the appropriate department at the university, but I didn't hear any conversation that the university is, we're just kind of, it seems weird to me, we're putting in law that the University of Wyoming, I know they have this process developed, but it's going to forever stay in statute. And I guess that's what concerns me. So any more testimony, it might be great for the 2024 cycle, but long-term, we're having the university put forth an algorithm every election cycle in perpetuity. So I guess I just want to make sure someone from the university testified that, you know, they can and will and are prepared to do this for the long term, and if there's any more conversation about it.
Representative Yin?
Madam Chairman, so that particular amendment that was in the standing committee amendment actually came from the Secretary of State. I think the committee just didn't have that much issue with it. But if there are questions about it, I think it's worthwhile to ask them.
Further discussion on the amendment? Representative Harrelson.
Thank you, Madam Chairman. So whenever we were in testimony, when we heard about this, the algorithm was built by the University of Wyoming and is being used by our clerks. So the University of Wyoming does not have to continue to do this. It was something they just built for us. We asked them, said, hey, we're concerned about this. We want an audit. And as they walked that out, this is something that is just, we plug numbers in, we get out the number of ballots that we need to go through and actually do an audit on. And so it's a simple algorithm that we plug our numbers into, so it would not add any more burden upon the university.
Any further discussion? Question having been called, all of those in favor of the Standing Committee Amendment number 1, say aye. Opposed, no. Standing Committee Amendment number 1 has been adopted. We're back on the bill. Further, Representative Chestic.
Thank you, Madam Chairman. I am curious to the members of the committee who heard this, what actual real-world Wyoming problems is this trying to solve? I know that some of the things in the bill we already do. The air gap is already there. We do that already. So what are the actual problems that this bill is attempting to solve?
Representative Yin.
Thank you, Madam Chairman. So a lot of the language is something that the prime sponsor worked with the County Clerks Association on, because it's stuff that the county clerks already do. So it's codification of a lot of the work the county clerks already do. The one point that I would like members to look at, though, is actually on page 4. So it keeps those that are voting via UACAVA, which is if you're in the military and you vote absentee, it keeps those folks from, because they're federally required, to receive ballots 45 days beforehand. What it does different, though, and this is a significant change, is that it reduces the amount of time that other people can vote absentee to 28 days. So it went from over a month and a half to 2 weeks that you can vote absentee. And so most of the county clerks actually do early voting, and they use absentee as the method to do early voting, and this actually shrinks that amount of time as well. So that was one thing that I was opposed to in committee, but I think it's up to each member to consider whether reducing the amount of time that people can vote is a good idea or not.
Further discussion? Question, I'm sorry, I see you. Representative Ottman.
Thank you, Madam Chairman. What I would say about the comment that was just made, we kind of wondered about that, how many days and whether to change it and if this was a big deal or whatever. The clerks actually said that the less days was advantageous to them, because going out to where it's 45 days, they have to have staff to take care of the ballots that come in. They have to have a place to put them. They have to have all of that while they're trying to get ready for the regular election. So they thought before that it worked well to have less days and that this actually would help them. So it went along with what they need in their office to make sure that things run smoothly and that there isn't a lot of time there to have any problems. So they were very for it. And the national average is shorter. Thank you.
Representative Yin.
Thank you, Madam Chair. So the clerks did say it would make election administration easier for them, right? So if you aren't having early voting for an extra couple of weeks, that makes it easier for them to staff. I think the question for the body is whether it's a worthwhile policy decision to have less days open for early voting. And there are states that have shorter early voting periods. The difference in a lot of states is that they actually accept ballots coming in later after the election. So we only accept the ballots up to the cutoff time for the election date. We don't actually accept ballots that get received after that absentee. So you do have a risk of when you shorten the period of allowable absentee voting, you might end up having more ballots that show up after election day that don't end up being counted. Thank you, Madam Chairman.
Before, Representative Chadwick, are you just there as the bill presenter? You're not wanting to speak? Okay, Representative Penn.
Thank you, Madam Chairwoman. So I stand in support of this bill. There's a question raised of, do we even need this? I would say that we do have a constitutional duty to uphold the purity of our elections. And that's what this attempts to do is fill any gaps that may be present. With regards to the air gap, I think that's very important to make sure that our machines aren't connected to the internet. Though I would say that this doesn't completely remove the concern, as if a machine were to have a digital modem inside, that can actually be turned on remotely and still access. So we still have work to do. This is a great start. And I would strongly support an aye vote. Thank you.
Representative Altman, are you wanting to speak again? Yeah, go ahead, Representative Altman.
Thank you, Madam Chairman. And just to say that this is to codify and also to streamline it a lot more for voters, and so that we can get, and there was a lot of conversation there, and the committee heard all of that conversation, and the vote, I believe, was, I think it was 8-1. So there was a lot of support for it, and it just is to make things run better, more efficient, to take a lot of pressure off of the county clerks who do that. The Secretary of State's office is for it, and we found it to be very advantageous in committee. So I would ask for an aye vote. Thank you.
Representative Pendergraft.
Thank you, Madam Chair. Just a comment on the amount of time for early voting. I know that in my county, early voting has started, and then after that, we had 2 or 3 forums. We had some debates, other information came out, and actually had constituents come to me and said, man, I wish I'd have known what I know now back before I voted. And so I think it's good to keep that a narrow window. We don't want to crimp it too much, but to keep it a narrow window to give contestants in any election an opportunity to debate publicly, and for information to come out rather than to have it just too wide.
Any further discussion? Question having been called, all those in favor of Chairman Olson's motion that when the committee of the whole rises to report it, do so with the recommendation that Senate File 153 do pass, say aye. Aye. Those opposed, no. Senate File 153 has passed the committee of the whole. The next bill for our consideration is Senate File 152. The reading clerk will read the bill.
Senate File 152, sponsored by Senator Pappas. Occupational Therapist, Criminal History, an act relating to criminal history records. Mr. Speaker, your committee number 1 Judiciary, to whom is referred Senate File 152, Occupational Therapist, Criminal History, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Chestick, Craigo, Haroldson, Nemec, Oakley, Provenza, Rodriguez-Williams, Washit. Noes, Representative Jennings. Representative Washit, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Washit?
Thank you, Madam Chair. I move that when the committee of the whole rise to report, do so with the recommendation that Senate File 152 do pass. And I would turn over the explanation to the lady in the chair, but instead I will do it myself.
Please proceed.
What we're doing with this bill, members, is simply providing for criminal history background checks on currently licensed occupational therapists and occupational therapist assistants. This is a requirement, and they're not presently identified in statute to allow us to do these background checks on those who are already currently licensed and they have to be currently licensed in order to join the interstate compact, and they have to have a background check before they can be part of the national compact. So one leads to the other. We have to authorize in statute so they can do the background checks. Once they do the background checks, then those therapists will be able to join the interstate compact if they wish. There are no amendments, so I ask if you have any questions, be happy to answer your questions.
Representative Ward.
Thank you, Madam Chairman. My question is, if this is required and is required for the pact, why was it not included in the pact bill? And why does it have to be a separate bill? So, thank you.
Representative Craigo.
Thank you, Madam Chairman. So just to respond to the previous question, the way this works is we have a statute regarding criminal background checks. It was included as part of the bill, but the good bureau that does our federal investigations has specific requirements on that language. And so this is just to get it. They didn't like the language we created, so we're just fixing that so that we can actually do the background checks. It's to fall in line with what they need us to do, what the language needs to say in our own criminal background laws, not necessarily the compact. It was addressed in the compact last year, but we apparently didn't get the language quite perfect. That's the short and the long of it.
Representative Locke.
Thank you, Madam Chairman. And I'm really just trying to get more clarification on that. And sorry, I didn't understand completely, but do we already have this background check requirement for our practitioners? And are we somehow correcting that, or is this adding that function? And if it is an add, is it for all of our practitioners or just those who choose to function in the PAC? Thank you.
Representative Craigo.
Thank you, Madam Chairman. So the answer to that question, we do not have this requirement for people who just practice within the state. This is to join the compact. If you want to be licensed under the compact, you have to go through the background, fingerprinting, et cetera. And so that's why this language is important for the bureau that does our federal investigations.
Any further discussion? Question having been called, all those in favor of Chairman Washett's motion that when the committee of the whole rises to report it, do so with the recommendation that Senate File 152 do pass. All those in favor say aye. Aye. Opposed, no? No. Senate File 152 is passed committee of the whole. The next bill for our consideration is Senate File 99. The reading clerk will read the bill.
Senate File 99, sponsored by Senator Barlow. Witnessing of wills, remote methods, an act relating to wills. Mr. Speaker, your committee number 1 Judiciary, to whom is referred Senate File 99 engrossed, witnessing of wills, remote method, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Chestick, Craigo, Haroldson, Nemec, Oakley, Provenza, Rodriguez, Williams, Washit. Noes, Representative Jennings. Representative Washit, Chairman.
You've heard the reading of the bill. What's your pleasure, Chairman Washit?
Thank you, Madam Chair. I move that when the committee of the whole rises to report, to do so with the recommendation that Senate File 99 do pass, and I turn over explanation of the bill to the professor at the back of the room.
Representative Chestick.
Thank you, Madam Chairman. This is a pretty straightforward and simple bill. It's basically codifies some of the learnings we had from the COVID era, in which it was sometimes difficult for testators to find witnesses to witness their wills. The first page, very simple, correcting at the very bottom, lines 14, 15, simply changes the way we refer to a section of the bill that deals with holographic wills, which are not covered by this bill. The main part of the bill is on page 2. It adds a new section, lines 14 to 20, which allows witnesses to a will to attend the will signing electronically through Zoom or some other method that allows audio video communication, so that the witnesses can actually see the testator as he or she signs the will. Has some requirements that The witnesses should be able to see and hear the testator in real time, have the opportunity to judge their competency, have the ability to securely sign the will, so that you don't need to actually sign the physical piece of paper. You can do an electronic signature on the will, and all of that will be sufficient to authenticate the will and make it a valid will under Wyoming statute. The rest of the bill has just some conforming language that for forms that add the possibility for electronic signature according to the new Section B. Very straightforward, and I'm happy to answer any questions.
Discussion on the bill, Representative Ottman.
Thank you, Madam Chairman. I just have one question for you. When you talked about competency, I wasn't quite sure what you meant, that was to verify the competency of the person making the will, verifying the will, signing the will, if it was a judgment call over this, or if you could just clarify that, please. Thank you.
And actually, I'm going to go to Representative Hornock, and then you can answer both questions. Go ahead, Representative.
Thank you, Madam Chairman. So we have notaries that typically sign this stuff. They validate your ID. They track this stuff. It's trackable that way. I'm just curious if this kind of usurps notaries as well. A will is a really important document at one point in time for everybody. It eventually gets to be very, very important. So just, curious how controllable this is. It seems like the notary process is very good, but, curious to get some thoughts on that.
Representative Chestick.
Thank you. So answering the first question first on competency, what that refers to is whether or not the testator has the ability to make a will, that they are mentally competent, they understand what they're doing, who they are, who their heirs may be, so that they're mentally capable, mentally competent to make a will. That's all that word refers to, and that's been around forever. That's a very common requirement in any state's intestacy statute. As for the second one, the role of a notary generally is not to evaluate the person signing, simply to say the person who signed is who they say they are, but does not, the notary public does not say that is a competent testator. That's for somebody who, the witnesses usually tend to be family members, other people who know the individual and can attest that the person is actually competent, knows what they're doing. And that's not the function of a notary. The notary requirement does not change at all. But the current statute does require witnesses to sign, people who are able to evaluate the competency of the testator, and that's, as I said, not the role of the notary.
Further discussion? Representative Locke.
Thank you, Madam Chairman. Is there anything lost in this video process in terms of verification of who the person is? I realize there's this video, there's this person on video, but at the risk of crossing the line of where is there any, in this formal documentation, is there some process to ensure the right person is actually signing, is being dealt with here? And I say that because everybody knows video is what it is, right? And it's like anything else. It can be faked very easily. So I just bring that up from this perspective, is what additional validation, other than the fact this guy's on video over here, this person's on video over here, is there to ensure that these wills, this is the right person, and yeah, they appear to be they appear to be of sound mind, if you will, but again, what additional process is in place to make sure it's the right person?
Chairman Olson.
Thank you, Madam Chairman. So I'll try to address that question as this is my practice area. This is what I've done for the better part of my legal career now, is practicing in trusts and estates. And so the number one check on that is actually, it's neither the interesting thing is this bill addresses the remote notarization of, or remote signature of witnesses, but it's really not in the witnesses that the biggest check takes place. The biggest check that takes place is going to be with the attorney. The attorney's going to know his or her client. The attorney's been working with the client. They've probably had a planning meeting. They've probably had a consultation meeting. At least one of those has probably been in person. And in person may have been by a Zoom meeting, or it may have been physically in their office. But the attorney themselves is going to know their client by the time they get to the signing. Most of these signings aren't. I think it would be very rare, especially if an attorney is working with the client, that they would just hand off the document and tell the client to go get it signed. Most of the time, the attorney is going to be conducting the signing as well, and the attorney is oftentimes the notary themselves. So the attorney is actually the one that has to walk through a process to, one, in this scenario, verify that the person is in fact the person, but that is in fact their client. But number two, they're also going to walk through a process of making sure that this person is competent, that they're of sound mind, that they're doing this in their own free will and accord, and that they're not under duress. It's the attorney's obligation to make sure all of those boxes are checked before the instrument is signed. Now, during COVID, I had the opportunity to do some of these. And during COVID, the way that we did it was we did it with Zoom technology. I shouldn't use that word. We did it with remote technology. There's plenty of platforms out there. And it's, I think the process is very similar to when a notary notarizes a document. All they do is check an ID. And so if they had never met, there may be that check as well where it takes place, where they have to present an ID before they sign. But all in all, folks, I think that the attorney is going to be the biggest check on who this person is and making sure they are who they say they are.
Representative Davis.
Thank you, Madam Chair. My father always said, if there is a will, there is a way. And I think there's too many loopholes in this way, so I'm against it.
Further discussion? Question being called. All those in favor of Chairman Washett's motion that when the committee of the whole rises to report it, do so with the recommendation that Senate File 99 do pass, say aye. Aye. Those opposed, no. No. Senate File 99 has passed the committee of the whole. The next bill for our consideration is Senate File 94. The reading clerk will read the bill.
Senate File 94, sponsored by Senator Ellis. Federal Indian Child Welfare Act codification, an act relating to domestic relations. Mr. Speaker, your committee number 2, appropriations, to whom's referred Senate File 94 engrossed. Federal Indian Child Welfare Act codification. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Walters, Swanitzer. Noes, Representative Stith. Representative Nicholas, Chairman.
You have heard the reading of the bill. What is your pleasure, Vice Chairman Larson?
Thank you, Madam Chairman. I move that when the Committee of the Whole rises to report it, do so that with the recommendation that House Bill number 94 do pass, and I will Senate File, thank you, Senate File 94 do pass. And Madam Chairman, I believe there's a Committee of the Whole amendment that will be coming forward, but if I may, I'd like to take the time to start explaining the bill. You folks, you'll recall that earlier, right out of the bat, when we got down here, we passed House Bill 19, which is the State Indian Child Welfare Act. We'll call that ICWA in this conversation, task force. And I shared with you how the Supreme Court is taking on a case that will determine whether that Indian Child Welfare Act proceeds or if it's overturned or components of it are overturned. I shared with you at the time also that federal law, the federal law, Indian Child Welfare Act law, has been in place since 1978, and it is the law that the state of Wyoming has complied with since that time. We have never adopted a state ICWA law. We've just complied with the federal law. So other states have done a little of both. They've drafted their own Indian Child Welfare Act that kind of tries to comply with the federal law, or they've amended the federal law in state statutes to do a little bit of both. So with the task force, we said to you that as we look at this really ought to be something that may need to be in state law, and if it does, how would that look? And so bringing those individuals, those stakeholders together over the next year, and then report back by July 1st of 2024 what our recommendations would be. So, what if in July of this year the Supreme Court overturns the federal law? How do we move forward? Fallback is to say that we just treat how we handle Native American children, Indian children in state courts, we do just like anybody else, which is a significant change from what we've done since 1978, which, if you'll recall, was that if there is an Indian child that for placement or for child protective actions, that the child's tribe also has a say in how the actions of that court. In Wyoming, with our two tribes, we do very well with that because we have a tribal court, and the two tribes have a tribal law and order code. And so in those counties that kind of have those two tribes in it, all of the child welfare cases go to tribal court. But the rest of the state, if you live up in the northeastern part of the state and you have somebody from South Dakota who's an enrolled member of one of those tribes that comes into state court, the responsibility then is to contact that tribe and to see if that child is going to be placed, can it be placed with other family members? Do they want jurisdiction first? Do we want to remand it over to their tribal court? And if not, how then would they like that child to be placed? Can it be placed with family or other tribal members, or is it their opinion that it would be in the best interest of the child to be placed somewhere near where the state court is located? So it might be still in Wyoming, and it might be in a non-Indian family. So what the trouble is with the Supreme Court, what we'll really be deciding is when we make this, or we making the decision based on the Indian tribes as a political classification or racial classification, and if the federal government in the ICWA law has overreached their 10th Amendment jurisdiction by saying this is how you will take care of the placement of child protective services within your state. That's always been an argument. That's going to be determined. And so the idea by putting this federal statute and codify it into state law is it gives us a bridge until we figure out. There's an amendment coming up that I think is a very good amendment, and would encourage you to adopt it, where everybody's saying, okay, we're a little uncomfortable bringing this federal statute and just dropping it in and codifying it into state law. Maybe it ought to be time sensitive. And so there's a sunset date in here of 2027 when that amendment comes. I think that's a reasonable approach. And next year, when the ICWA Task Force presents its findings and recommendations back, then it allows yet a couple more legislative sessions to try and get whatever recommendations, if any, implemented. So with that, Mr. Chairman, I'd be happy to answer any other questions regarding this act.
Thank you, Representative Penn.
Thank you, Madam Chairman. At this time, I have an amendment. So if this time I move Committee of the Whole Amendment number 1 for Senate File 94 and ask for your favorable consideration. As was just discussed, this amendment is to put a sunset date on this ICWA law of July 1st, 2027, in attempts to make this more palatable to the body. The concern, of course, is we don't know at this point what's going to happen with the Supreme Court ruling. They could completely overturn it and deem it unconstitutional. They could make different changes, and therefore, we're not putting this into law in complete perpetuity, but with the ICWA task force bill that has come through, we have that opportunity to take some time and look at what changes need to be made and improvements, and this allows for that. So I would ask for your aye vote. Thank you.
We are on Committee of the Whole Amendment number 1. Is there any further discussion on that? Is that what, Representative Ward?
Thank you, Madam Chairwoman. I am in support of amendment number 1, but against the bill. So I'll leave it at that for now.
On the amendment, Representative Chestic?
Thank you, Madam Chairman. I'm just curious, there's two ways of handling the situation. One is that we could simply wait for future events, and if the future events make this bill unnecessary, we can go back and repeal it. Or the sunset choice is kind of it automatically repeals it, and if we want to reenact it, we have to come back and reenact it. I'm just curious as to why we chose the pre-repeal, I guess, rather than just wait until we see what happens later on and then come back and repeal if necessary.
Representative Penn?
Thank you, Madam Chairman. So discussions were had with the tribal attorney and with the bringer of the bill, who also practices tribal law, and ultimately this decision was arrived at, feeling like this was most appropriate. Thank you.
Representative Stith, are you? No, okay. Is there any further on the amendment? Okay, question being called. All those in favor of Committee of the Whole Amendment number 1, say aye. Opposed, no. The amendment is adopted. Back on the bill. Representative Stith.
Madam Chairman, thank you very much. I speak against Senate File 94, the Indian Child Welfare Act, for a number of reasons. First and foremost, this act discriminates against Native children who, under the bill, do not have the same rights as non-Native children to be raised in a home that is in their individual best interest. What the federal ICWA law does is it sets the value of the group, the tribe, above the individual interests of the child. You'll notice that nowhere in this bill does it ever use the phrase best interests of the child, of the individual child. And it doesn't use that phrase because ICWA is set up so that the individual best interests of the child are not the priority. The priority is the group. This bill, as you can tell, also makes a race-based classification. On it's the easiest place to see that is on page 14 of the bill. It talks about shelter care and pre-adoptive placement. And starting on the bottom of page 13, it lists the priorities of placement. And the first placement is a member of the Indian child's extended family. Second placement, other members of the Indian child's tribe, other Indian families, the top of page 14. And then page 14, line 4, says an institution for children approved by an Indian tribe or operated by an Indian organization that has a program suitable to meet the Indian child's needs. And then last priority is any other placement. And any other placement means with a non-Native family. So what this bill says is that the child, an Indian child, will be first put into an Indian group home before being placed with a non-Native family. That is, and it makes this classification between Native and non-Native is basically a race-based classification. On page 9, it also adopts a burden of proof that is found nowhere else in the civil law. At the bottom of page 9, when it talks about adoption, lines 22 and 23, it says, no termination of parental rights over an Indian child shall be ordered unless the court determines beyond a reasonable doubt that the continued custody of the child by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child. That is not a standard that you have for non-native children. So native children have this standard for termination of parental rights such that it can essentially never happen. The beyond a reasonable doubt standard is a criminal standard, not a civil standard. This bill is federal law that the federal government adopted in 1978. In my view, it doesn't make any sense for the state of Wyoming to adopt wholesale a federal statute. It doesn't make any sense. It's race-based, and the equality state, there are those who believe that you can make a race-based classification for good purposes. There are those who believe that there is good racism and bad racism. I do not believe that. I believe racism is bad, period. And the equality state should not endorse racism. So on and against Senate File 94.
Representative Pendergraft.
Thank you, Madam Chair. I'm really struggling with this bill, and the previous speaker spoke to many of the concerns that I have. My understanding is that we're looking at codifying in Wyoming law, a law from the nation, a federal law. And my understanding further is that any law that we make in the state of Wyoming has to fall under the Constitution. It has to follow that form. You don't have to read very far into the Constitution when you see in their inherent right to life, liberty, and the pursuit of happiness, all members of the human race are equal. And that's followed up by, since equality and the enjoyment of natural and civil rights is only made sure through political equality, the laws of this state affecting the political rights and privileges of its citizens shall be without distinction of race, color, sex, or any circumstance or condition whatsoever other than the individual competency and unworthiness duly ascertained by a court of competent jurisdiction. On and against the bill.
Representative Ward.
Thank you, Madam Chairwoman. I echo the concerns of the good representative from District 48 and urge a no vote on this bill. It violates equal protection under the law, and it is before the Supreme Court of the land. I urge a no vote.
Representative Hornock.
Thank you, Madam Chair. So I have a question on this. If there is a pending court case that our nation's highest court is going to listen to, is this bill kind of signing wholesale what that federal government law is concerning ICWA, or have we solved that problem that's pending in litigation in here, so that we can avoid that now? It doesn't seem to make sense that if we are signing something into law that's basically directly word for word, we're taking the federal government statute and putting it into Wyoming statute at this point in time. If there's a pending court case, what have we done to solve that issue in this before we go ahead and sign this into Wyoming law? Thank you.
Representative Chestick.
Thank you, Madam Chair. On and in favor of the bill. Several of the previous speakers have said that this is racism. It's a race-based classification. I would dispute that. This is not race-based discrimination. It's not a race-based category. It's a culture-based category. I think in order to understand why the federal ICWA bill exists in the first place, you need to understand a little bit about our history, American history, and how assigning non-Indian parents, or allowing non-Indian parents to adopt Indian children was one technique that was used in history to try and eliminate the tribes. Let's be frank about that. Let's be honest. Back in our history, not recently, but in our not so distant past, there was an express effort by the federal government to destroy the Indian culture and assimilate Indians into Western culture, European descendants. And one of the tools they used was Indian schools, where they ripped children away from their native families, put them in Indian schools, and tried to teach them Western ways, tried to erase the Indianness of them, and placing children into white families was another technique. It was an attempt to eliminate the Indian culture. So this is a culture-based thing, not a race-based thing. It's a culture-based thing. And that's why ICWA, the federal ICWA, was adopted to prevent that tool, to prevent us from still doing that. It was an effort to save the Indian culture. And that, I think, is a good thing. I am very much in favor of saving the Indian culture. It's a different way of living. Yes, it is, but it is a perfectly valid, legitimate way of living, and one that is treasured by a number of members of the Indian tribes. So if federal ICWA goes away, I'm 100% behind replacing it with a state ICWA. And I'm very much in favor of this bill, and I urge your aye vote.
Representative Larson.
I think thank you, Madam Chairman, and I appreciate the conversation in a little bit in an effort, because I know we have a busy day trying to do that. I perhaps rush through this a little bit. I find it interesting that this morning we talk about abortion, we go upstairs and we talk about transgender, then we'll talk about how we do minerals, then we'll come in here and talk about Indian child welfare. Did any of you think we'd be talking about all these different things when you signed up for this job? And then to know that our constituents expect us to pass out a just and equitable decision for them. I think the challenge for us in this position is my good colleague who I serve with on the Appropriations Committee talks about discrimination. However, none of you have not received any emails from any of the tribes saying, please don't do this. We're discriminated against in this act. And you don't see anybody in this body who by blood can represent their concerns. So here's this old fat gray-haired white guy up here standing trying to do his best to make sure that we, with this sovereign group that lives within the boundaries of our state, that we're trying to allow them to make sure that the pendulum that prior to 1978 had swung off to one side, where that 25% of all tribal homes had at least one child removed from their home, and 85% of those removed went to non-native homes. So they went into white homes, where then we took it upon ourselves, and I'm not going to, I'm just factually, where then we tried to assimilate them into whatever it is we felt was appropriate. And I don't think, for most cases, I don't think malice was intended, but I think that we discovered prior to 1978 with the boarding schools and whatnot, where they weren't allowed to speak their language, where they weren't allowed to learn their culture, where they weren't allowed to do these things, that perhaps as smart as we and as charitable as we felt that we were in saving them from themselves, maybe we done a little injustice. And so it was created, and the concern on whether it's a race-based decision, we've granted them by congressional action a sovereignty. They're a sovereign nation, and so when a sovereign, I believe, has a right to be able to have a say in the disposition of the affairs that affect their people. And so even though this is a race, they also are sovereigns. And if the Supreme Court overturns ICWA in the Bracken case and does away in truly does say that this is a race issue, it's going to turn on its ear the relationship we've had with tribes for the last longer than your grandparents were alive. So when we talk about equality, race, and individualism, that we're the equality state, that I couldn't agree with you more. We are the equality state, and so why would we not allow them to have the ability to be self-determined on how they feel they ought to protect their culture, granted through treaty rights, the ability to determine where and how their children are placed. Now, you've all received lots of emails sharing with it. We had an article in the newspaper about the horrific situations that have happened to children that were taken out of a stable foster home and sent back on perhaps to a reservation where things happened that were unfortunate. Is that right? No. Did it happen? We know that it did. Do we support that? No. It's a fine thing, but I will just share with you, having been on this committee for a long time and having served and interacted with the two tribes in my part of the world, that's a two-way street. And what you don't hear, because our good friends who live in those communities aren't sharing with you the similar inappropriate things that happen to these children when they're placed outside their culture. So to think that we're as pure as the wind-driven snow and free from any type of abuse or inappropriate action, I would just suggest to you is false. So at the end of the day, and I'd like to answer the good representative from over here, can this bill, by putting this in here, solve anything? No, it won't. It's merely a bridge to say, we're going to take what we've been doing since 1978, allow it to happen until we get done with this adopted amendment no longer than 2027, and hopefully we figure out an appropriate way. Wyoming, as you said to me, the equality state, to determine the appropriate way to care for the jurisdiction of civil proceedings for these child custody cases in Wyoming. So I don't have a second verse. That's the best I got, and would encourage an aye vote, but happy to try and answer any additional questions.
Representative Haroldson.
Thank you, Madam Chairman. So a couple speakers back, we heard the reasons why this this originally was brought into existence, because there were issues. I mean, I don't think anyone in this place is saying that there wasn't. There were issues with these children being trying to remove them from their culture and bringing them into a different culture. We got to see some injustices, some horrible injustices. But I think it's pretty safe to say that that isn't the case anymore. That's one of the reasons why we're seeing it where it's at on the federal level, is even the federal government in that branch is saying there's some questions we really have to ask. And so what we're looking at here is why would we, if we pass this through, why would we take kids out of stable homes, safe homes, and put them into a place potentially that isn't? My wife and I went through this last year. We went through training for our foster system. One of the things that we're realizing in our community is this is a major need. And one of the things that they push and push and push is that when we find a stable home for these children, that is the most important thing, is a stable home. Obviously, we want to bring them back into a stable home with their parents. That's the ultimate what we want. But if that isn't an option, once we get stability for them, we want to keep stability for them. And I would venture to guess if we pass this, there's a very real chance that we're going to take kids out of stable situations and put them back into unstable. The second thing is a very big aspect that they talked about and they pushed was group homes is not the answer for stability. And if we do this, there's a very good chance we'll be placing kids back into group homes. And so you guys have to be thinking about this. There's a reason why this is in question right now, and we need to be very careful that we don't step into creating a bigger issue than is already there. The foster system's a big issue. It needs a renovation. I'm not going to disagree with that at all. But I don't believe that this is a renovation in any way, shape, or form. So I would ask you to vote no.
Representative Penn.
Thank you, Madam Chairman. The previous two speakers have done a good job of pointing out different points, so I won't belabor the point other than just to say that the tribes are asking for this. The department that deals with service of families as a whole needs some attention and probably some reform. We're not going to fix that in this bill today. I would just urge an aye vote on this. Thank you.
Further discussion, Representative Larson?
I'll try and, I thank you, Madam Chairman, and I appreciate, but there's the speaker before the last one that says we need to be careful because we will be taking, if we pass this, we'll be taking children out of stable homes. It's the law now. It's the law that we're complying with. We're not changing anything. We're just bridging it to where we see that. What is a stable home? You know, is it the way you raised your children with your grandparents, or is it the way I raised mine? Certainly it couldn't be the way you raised yours, so I don't know really how we define that completely. However, we do know that when we look back historically and we see that we took the children away from these families and I don't know of a better word to say, but robbed them of their culture. And, you know, they may have felt very comfortable. I would argue that they felt very comfortable being in the non-European family structure that they, for generations and generations and generations, had lived with, coping to how we feel a stable home is, outside of abuse, is very important. Now, I will share to the last Breener, she talks about that agency that oversees children, and this is really important because our state agency that oversees child services does indeed get involved with the placement of these children and children protective services outside the reservation. Boom. So if it's a child from Crow tribe or a tribe from Florida or a tribe from Utah or Arizona and come into outside the reservation, within the reservation, these good, solid foster homes are under the jurisdiction of tribal. Each tribe has their own Department of Family Services. And so there's good, solid foster care on the reservation as well as off the reservation. So, sorry, Madam Chairman, I'll be quiet. Encourage an aye vote.
Representative Claston?
Thank you, Madam Chairwoman. You know, both tribes are in favor of this law. This law doesn't change anything. I think we need to respect the wishes of these tribes and how they handle their own culture. I'm going to encourage an aye vote on this.
Representative Strzok?
Thank you, Madam Chair. I would say that a stable home would be cleanliness, running water, heat, food, and I would really, that has to happen in both. It doesn't matter if you're on the reservation or not, and we really need to look about what's happening on the reservation, and that's the reason they shouldn't always be sent back to the reservation. That's what's lacking in a lot of those situations, so I would encourage a no on this. Thank you.
Representative Hornock?
Thank you, Madam Chairman. So obviously this is a pretty important topic for us to really actually get right. I think we do have one shot at this, and I don't know that that we're necessarily going to solve it. I have a couple questions still, and I don't know that I'm quite satisfied with the answer. But so if we adopt this law, how does Wyoming avoid a lawsuit over this? Are we going to then potentially tie up Attorney General resources and things over a fairly drawn-out lawsuit that's happening right now on the federal level? And then also, what is the harm in waiting, in listening to the task force? It seems like that task force is going to bring the tribes together, bring people together, try to tailor what we're going to do and fit it here in Wyoming, because this is an issue here in Wyoming. We have tribes in Wyoming. I'm sure that we deal with these kind of kids in Wyoming. What's the harm? I think that task force goes till the end of 2024 or something like that. I don't remember specifically. I didn't look it up before I got up here, but we've given them a mandate to figure this out and to tailor it for Wyoming. What's the harm in letting that happen and then coming with a bill that works for what we're dealing with here with our particular tribes and our particular environment? Thank you.
Representative Swanitzer.
Thank you, Madam Chairman. The harm is ICWA is a federal law, and you're dropping a federal law into state law, and it involves a lot more than our tribes. And so my question to the bringer, and has this been contemplated, is can we specify that this is for the 2 tribes in Wyoming? Because ICWA, for those of you who had to deal with this like I have, this is any Indian child from any tribe anywhere in the country. They end up in Wyoming, they come into the system. Maybe they're just driving through the state, right? And can we tailor this? Because if the Supreme Court does what we all think it probably will do, I mean, every state's going to have an issue and interstate commerce and kids for different tribes. Is there a way forward if we specify we have a Wyoming solution for the 2 tribes and those children in our state that fall under this, but we don't have to abide by the ICWA rules? Should that Supreme Court case go how it looks like it's going to go, and then we can at least not be subject to all the different federal requirements that fall under now. So if the good bringers of the bill wouldn't mind addressing that, if there's conversation, can we tailor this to Wyoming citizens in our state?
Representative Ward.
Thank you, Madam Chairwoman. I again urge a no vote on this bill. Enforcement like this has resulted in children being pulled out of loving families and put into crowded group homes or placed in homes with no heat or running water. It creates inconsistencies within Wyoming law on how to determine the outcome of children based on race. Please vote no.
Representative Ottman.
Thank you, Madam Chairman. Having the opportunity to meet a lot of the people that we talk about in this bill over the last 25 years, I would just say I have seen those children that have been placed because of extenuating circumstances into homes that were not Indian. And the reason being is because at the time there was no availability with the tribes to do that. As someone said, sometimes they're taken back because of tribal sovereignty and put into homes where there isn't food or water, and a lot of times it's because there's so many people living in one place. I wanted to run an amendment to wait on this bill and was asked to withdraw that, which I did, because we all want what's best. The thing is that the governor feels, and apparently some people here, that this is the best way to go with this. I still wasn't sure because it is about the children, even though we're talking about sovereignty and governing and who's in charge. This basically should be about the children. The tribes have asked that they be given time to reorganize and to make things right. The main reason that I see that they want this bill to go is for the when and if the Supreme Court says that this is not no longer something that they're going to do or should do, that the tribes would have the opportunity to rule themselves. I'm still not sure on it. I called DFS in my town and talked, or the family department that takes care of children in my town, and asked about these things, and they said, oh, we're ironing those things out. Then I called both tribes and asked the departments, are you up to speed? Do you have the same requirements and laws as the state of Wyoming does? They said that they were working with it and that they were trying. All of those things I really do not know. What I do know is that it's about the kids. There are children on that reservation that are raising themselves that nobody knows where they are. One of the big issues in this state is missing and indigenous people, okay? Why, if it is so safe there and the families are so intact and they're able to take care of these children, why are we having these problems? So I don't know what the answer is, but I just think it needs to be well thought out. Thank you.
Representative Chestick?
Thank you, Madam Chair. Going back to to the very first comment that was made, and that is that this bill does not seem to account for the gold standard of child custody, and that is the best interest of the child. I think it does, actually. I think this bill sets, is a statement that preserving the child's culture is in the best interest of that child. Imagine taking a child who's 6, 7, 8 years old, their parents die for whatever reason, they need to be fostered somewhere, they need to be adopted somewhere, and having that adoption go to a white family, a very different culture, is probably not in the best interest of that child. They've been raised in the indigenous culture, and this bill says that is in the best interest to preserve their culture. I'm sensing, just from the discussion, the debate here so far, that we think, or some members of the body seem to have a feeling that having running water is in the best interest of the child. But that's a Western value. People have lived without running water in their homes for centuries. That's a new thing culturally. If we don't pass this bill, we are basically reversing the statement that this bill makes. This bill makes a statement that preserving the culture of that child is in the best interest of that child and of the culture of that nation. And if we don't pass it, we're saying the opposite is true. I don't believe the opposite is true. I think preserving the native ways and the indigenous culture is a great value and is in the best interest of everybody, the tribe and the children. And therefore, I strongly urge an aye vote on this bill.
Vice Chairman Larson, please bring us home.
I will. So if we adopt the law, does it put the state in jeopardy? No, it isn't. Again, it's a bridge to continue doing what we're already doing. It does not put the state in jeopardy. Specify, the good Chairman Labor asked if we could just tailor this to the 2 tribes in Wyoming. I suppose you could, but that's probably not as much the issue, again, because the intent is for these children to be heard in a tribal court and be placed in tribal situations. So our 2 tribes really, for their enrolled members, are able to do the majority of that now. It's for the rest of the state who have Indian children who come into state court where there are custody proceedings and whatnot that this really remains important. And I think that, Madam Chairman, the comment on these horrible conditions, water, maybe no running water and stuff, I will concede. I've heard of people in this state as young as 9 and 10 being forced to get up and drive tractors to help rake hay from sunup to sundown. I've even heard, Madam Chairman, I've even heard some people force children, mind you, children, to get up before dawn, get on a horse, and move cattle all day long. I can't fathom. I mean, it's beyond me to think that somebody would subject children to such conditions and think that it be appropriate. Just can't imagine. I just think that sometimes it might be helpful if we walked in their shoes a little bit and understood this issue from their perspective and not always from the perspective from another state or another deal. So again, I think that this is an important thing that we should move forward, put it in. I really think the amendment to put the time limit on there is a good thing. Please, can we ask the question?
Question being called. All those in favor of Vice Chairman Larson's motion that when the Committee of the Whole rises to report it, do so with the recommendation that Senate File 94 do pass, say aye. Aye. Those opposed, no? No. Chairs in doubt? All those in favor, please rise. Thank you. All those opposed, please rise. Yeah, for less than 34 is what they got. Do I need to announce that? 34-21, Senate File 94 is passed, the Committee of the Whole. So members, and for everyone tuning in and watching, and we have to read some bills in, so we're going to go out of Committee of the Whole briefly and get that done, and then we'll get back to work on these general file. As we've said, we plan on getting through these today, so I would also just urge everybody in the body to keep that in mind and keep debate as tight as we can, because we do plan on getting through these bills on general file. Majority Floor Leader Nyman.
Madam Chairman, I move the Committee of the Whole begs leave to rise and sit again. Oh, we're going out. Yep. Good. Very good. Strike that. Chairman, I move that the Committee of the Whole rise and report.
All those in favor of Majority Floor Leader Nyman's motion, please say aye. Aye. Opposed, no? That is passed. Do I say?
The reading clerk will read the Committee of the Whole report.
Mr. Speaker, your Committee of the Whole, having had under consideration bills on general file, begs leave to report as follows. Senate File 181, do pass amended. Senate File 109, do pass amended. We rose and sit again at 1400 hours, 2 o'clock p.m. We came back into session. Senate File 164, do pass amended. Senate File 153, do pass amended. Senate File 99, do pass amended. Senate File 94, do pass amended. Representative Western and Representative Oakley, Chairman.
Chairman Oakley.
Mr. Speaker, I move the adoption of the Committee of the Whole report.
You have heard the motion. All those in favor say aye. All those opposed, no. Motion carries. Reports from standing committees.
Senate File 127, sponsored by Blockchain, Wyoming Stable Token Act, an act relating to trade and commerce. Mr. Speaker, your Committee Number 2 Appropriations, to whom is referred Senate File 127 engrossed, Wyoming Stable Token Act, respectfully report same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Zwanitzer. Representative Nicholas, Chairman. Senate File 136, sponsored by Senator Beitman, Property Tax Relief Assessment Rate Reduction, an act relating to taxation. Mr. Speaker, your Committee Number 2 Appropriations, to whom is referred Senate File 136 engrossed, Property Tax Relief Assessment Rate Reduction, respectfully report same back to the House with a recommendation that do pass failed in accordance with House Rule 5-4. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Zwanitzer. Representative Nicholas, Chairman. Senate File 133, sponsored by Senator Schuler, Student Eligibility in Interscholastic Sports, an act relating to education. Mr. Speaker, your Committee Number 2 Appropriations, to whom is referred Senate File 133 engrossed, Student Eligibility in Interscholastic Sports, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Larson, Nicholas, Stith, Walters. Noes, Representatives Henderson, Sherwood, Zwanitzer. Representative Nicholas, Chairman.
Okay, we're at that order of business of request to concur with Senate amendments to House bills. The first message for our consideration is message number 439 on House Bill 123, Chairman Newsom or Vice Chairman Western. Perhaps I don't have anybody. All right. Not Chairman, there's Majority Whip Western. Oh. All right, Chairman Newsom.
Speaker, sorry for the delay. I move message number 439 to House Bill 128 and would appreciate a vote for concurrence. I've consulted with the sponsor of the bill and he's good with concurrence. So please vote aye.
We're voting on the motion to concur.
123, House Bill 123.
We're voting on the motion to concur with Senate amendments to House Bill 123. A majority of the elected members is required. The Chief Clerk will please call the roll.
Point of order.
What's your point?
Mr. Chairman, I can't find it. I have no idea what I'm voting on.
All right. We'll stand at ease and see if you can find it.
Mr. Speaker, it's not online. I don't know if it needs to be, if there's somebody else that has it or that we can share it and actually explain maybe what the concurrence and the amendments were done on the other side. That might help a little bit, but we're having troubles even finding it online.
So what we're going to do, well, it's already been moved. So what we're going to do is hold this for a minute. We'll just stand at ease for a second. I thought this would be fast. I was wrong.
So what I'm going to do is I'm going to set this aside for the moment. I'm going to sign a few enrolled acts until we get that concurrence up online, and then we'll run through that, and then we'll go back into committee of the whole. It's online now. All right, we're back on concurrence. So Chairman Newsom, maybe Chairman Newsom, either have you or the bringer of the bill maybe explain in more detail on this concurrence message.
I turn the concurrence over to the good representative that sponsored the bill.
Representative Berger.
Thank you, Mr. Speaker. So I encourage your aye vote on this concurrence. First, what this concurrence does is they take out the piece of the ownership of the antlers from Game and Fish. It's already in statute and some other places, so we don't have to say it 3 or 4 times. And then the other part of this concurrence is just changing instead of 3 days for residents to Hornot, they changed it to 7. And the reason being is they thought about it, and the good people over on the other hall said, May 1st is the day in these seasons, and if May 1st is on a Monday or a Tuesday or a Wednesday, they don't get a weekend. And we thought, yeah, that would be fair enough, and thought 7 days. We'd contemplated 7 before, and thought 7 was absolutely fair for residents to have that advantage. Thank you.
All right, we are voting on the motion to concur with Senate amendments to House Bill 123. A majority of the elected members is required. The chief clerk will please call the roll.
Elliman, Allred, Andrew, Angelos, Banks, Bear, Berger, Brown, Burkhart, Byron, Chadwick, Chestick, Clauston, Conrad, Crago, Davis, Eklund, Haroldson, Harshman, Heiner, Henderson, Warnock, Jennings, Knapp, Larson Lloyd, Larson JT, Lawley, Locke, Nyman, Newsom, Nicholas, Nemec, Northrup, Oakley, Obermuller, O'Hearn, Olson, Ottman, Pendergraft, Penn, Provenza, Rodriguez-Williams, Sherwood, Singh, Slagle, Smith, Stith, Storer, Strock, Stivar, Tarver, Trujillo, Walters, Ward, Washut, Western, Winter, Wiley, Yin, Zwanitzer Dan, Zwanitzer Dave, Speaker Summers. Are there any changes? Are there any changes? Closing vote. Vote closed. 44 aye, 17 no, 1 excused.
By your vote, you have voted to concur with Senate amendments to House Bill 123. We're at that order of business of signing of enrolled acts. The first enrolled act for our consideration is House Enrolled Act number 72. The reading clerk will read the enrolled act.
House Enrolled Act 72, being original House Bill 11, an act relating to retirement, providing for full-time state park ranger participation in the law enforcement plan under the Wyoming Retirement Act, making conforming amendments, authorizing election by current full-time state park rangers, specifying implementation, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I am about to sign House Enrolled Act number 72, being original House Bill number 11. I have so signed. The next enrolled act for our consideration is House Enrolled Act number 73. The reading clerk will read the enrolled act.
House Enrolled Act number 73, being original House Bill 200, an act relating to game and fish, modifying the provisions of elk, deer, antelope, bighorn sheep, mountain goat, moose, grizzly bear, and wild bison hunting licenses issued to non-resident applicants, increasing non-resident license fees to hunt elk, deer, antelope, bighorn sheep, mountain goat, moose, grizzly bear, and wild bison, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I am about to sign House Enrolled Act number 73, being original House Bill number 200. I have so signed. Congratulations, Representative Northrup. The next enrolled act for our consideration is House Enrolled Act number 74. The reading clerk will read the enrolled act.
House Enrolled Act number 74, being original House Bill 2, an act relating to cities and towns, providing that elected and appointed officers may elect not to receive a salary or compensation while serving as elected or appointed officers, providing legislative intent and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I am about to sign House Enrolled Act number 74, being original House Bill number 2. I have so signed. Congratulations, Representative Heiner. The next enrolled act for our consideration is House Enrolled Act number 75. The reading clerk will read the enrolled act.
House Enrolled Act number 75, being original House Bill 99, an act relating to property tax, amending qualifications for the property tax refund program, amending qualifications for the county optional property tax refund program, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign House Enrolled Act number 75, being original House Bill number 99. I have so signed. The next enrolled act for our consideration is House Enrolled Act number 76. The reading clerk will read the enrolled act.
House Enrolled Act number 76, being original House Bill 276, an act relating to game and fish, providing that any shed antlers and horns on state or public land are the property of the state, requiring non-residents to obtain a conservation stamp to collect shed antlers and horns on state or public land, providing exceptions, specifying fees, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign House Enrolled Act number 76, being original House Bill number 276. I have so signed. Congratulations, Representative Wiley. Mr. Majority Floor Leader.
Mr. Speaker, I move the House resolve itself into committee of the whole.
You have heard the motion. All those in favor say aye. All those opposed, no. Motion carries. Chairman Oakley.
So the committee of the whole will come to order. The next bill for our consideration is Senate File 72.
Senate File 72, sponsored by Senator Larson. Employees forced microchip implantation prohibited. an act relating to labor and employment. Mr. Speaker, your committee number 10, Labor, Health, and Social Services, to whom is referred Senate File 72 engrossed. Employees, forced microchip implantation prohibited. Respectful report, same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Clauston, Hornock, O'Hearn, Penn, Trujillo, Ward, Swanitzer. Noes, Representatives Chadwick, Yin. Representative Swanitzer, Chairman.
You've heard the reading of the bill. What is your pleasure? Chairman Zwanitzer.
Thank you, Madam Chairman. I move in the Committee of the Whole rise to report to do so with the recommendation that Senate File 72 do pass. Would further move the standing committee amendment and turn it over to the good representative from Natrona County.
Representative Locke.
Thank you, Madam Chairman. So I'd like to introduce this bill, and as you heard, the title is it's employee forced microchip implementation prohibited. And let me just kind of put this in perspective, and I think a lot of people are going to ask, well, why is this a problem? As many of you know, or some of you know, this is starting to become a thing. So I'm throwing this out there, and it's not really extremely prevalent currently in this country. It is happening in some areas. It's happening in other countries very frequently now. And so it's starting to move along. So the objective of this bill was to just put this in place in advance, be proactive, put it in place, and basically protect this simple individual freedom for everyone. So let me talk just a little bit to the bill, try to summarize it a little bit. I'll do my best to summarize. And if the bottom, basically, fairly quickly, we'll just look at the bottom of page 1 and 2, just definitions. But the most important part of this really is when we start down at the bottom of page 2, and really the objective of this bill, and again, I'll try to summarize a little bit, is just that no employer shall ask an applicant or an employee, during an interview or any prospective during an interview or in an application to consent to having a microchip, to be required to have a microchip implanted. And so just to summarize the other one, the objective here is just to make it to where employees can't, impose or coerce people to do this. That's the objective. We're not, one of the things this bill does not do is try to block the employer's ability to track an employee. I know currently out in the business space, they have trackers in the vehicles. It's not uncommon, I think, in many businesses for them to have people while they're at work to have trackers on them. This is not looking to do that. This is just looking to ensure that for employment, for advancement in employment, make sure there's no option for them to have an adverse action because you don't choose to have an invasive implant of a chip into a person. That's what this entire bill is all about. And I suspect there's quite a few questions that I will miss in this initial round. But again, the most important thing is just it's trying to avoid this invasive function only. It's really not looking to block the employer's right to track, my employers are on the job while they're at work. That's where this entire bill is going. It does have some additional provisions in here when you go through this. And some of that is, so if an employee chooses to have an implant, that is certainly within their rights. But the other thing that this bill does do is give some rights to where if an employer says, hey, geez, we want to put this in there, it does give that employee notification, complete exposure of what type of information is being used and tracked. So when if a person does choose to have a microchip implanted, they understand the full and comprehensive nature of what's being done to them. So that's some of the major portions of this bill. I know I didn't hit it in a lot of detail. The one thing I do want to throw out there, and again, I'm going to stress this a little bit, in the last paragraph, you'll see that nothing in this section shall be construed to prohibit an employer from using alternative non-invasive technology for reasonable operations of the employer. Again, I know the cable truck maintenance trucks are all tracked. I know in some cases people are tracked for safety reasons. I could imagine, and I don't know this space well, but I could imagine in mines and things like that, it's appropriate from a safety perspective. The goal is not to impose put something in place that causes a problem in those areas. We want to make sure those capabilities still exist. It's really just this invasive component. A lot of folks are going to say, hey, where's the problem? This is just to kind of be proactive and say this simple individual right, we're going to make sure we protect it at all costs. I'd like to have your eye on this bill. I think it's a great bill, and I obviously would love to hear your questions according to that. I believe there is a standing committee amendment. If you'd like me to, I can, Mr. Chairman. Okay, thank you. I'll go ahead and there was a standing committee amendment, sorry. So I move standing committee amendment number 1 to Senate File 72. And let me just read that in, just so everybody understands, is all it affects is on page 3, Romanet 1. It just added some text to that paragraph. So in short, that paragraph reads, state on an application for an employee or during an interview that a prospective employee will consent to having a microchip implanted in his body. Must consent to having a microchip implanted in his body. So it really didn't significantly change the intent of that paragraph, just made it a little simpler. Talked with the bringer of the bill. He did not have any issue with that, so I consider it a very friendly amendment. And I would actually ask for questions on the amendment if there's no discussion.
Any further discussion or questions on the amendment? Question having been called, all those in favor of the standing committee amendment number 1, say aye.
Aye.
Opposed, no. Standing committee amendment number 1 has been adopted. We're back on the bill. Representative Sherwood, can you?
Thank you, Madam Speaker. It is kind of the short no man's land over here. So it's been a long session. It's been a long Monday. So if I've missed this, I apologize. But what Wyoming problem are we trying to solve with this bill? If you could answer that question for me, I would deeply appreciate it. Thank you.
Representative Yin. Oh, Representative Locke, did you want? Representative Yin.
Madam Chairman, I mean, my answer is there are 0 companies in the entire United States that do this. And I mean, after answering that, I think I'm going to move my committee of the whole amendment. So I'll move committee of the whole amendment number 1 to Senate file number 72 and ask for your favorable consideration. So members, all this committee of the whole amendment does is if you look on page 4, line 11, it changes that colon to provided that the implantation is voluntary, and then it gets rid of all of the requirements around voluntary implantation. So the bill still would prohibit involuntary implantation, but voluntary implantation just wouldn't have any requirements over it, because I'm not sure why we would restrict that in any way when it's an association between an individual and a business doing it voluntary. I don't know why we would put those requirements on business. So this just increases the amount of freedom of association when those are doing it voluntary. So I'll ask for your favorable consideration. And again, no companies are doing this in the entire country.
So we're on committee of the whole amendment number 1, discussion on the amendment. Representative Locke.
Thank you, Madam Chairman. So I'm on and against the amendment. The amendment does take out some protections for people who actually choose. If you look at the amendment, you'll see that it takes out some sections on page 4, where those are actually some of the protections for people who voluntarily do choose, um, who do choose to have that done, but it provides some additional protections for them to ensure that that they actually do consent, which is maybe a logical thing. And even though the microchip may be implanted, let's see here, the employee can then have the microchip removed at any time. So it just gives some additional explicitly documented protections for a person who actually does accept the, does voluntarily allow that to be done. So I am on and against the amendment from what it removes, so.
Is there any further discussion on the amendment? Okay, question having been called, all those in favor of committee of the whole amendment number 1, say aye. Opposed, no. The amendment has failed. Division being called. All those in favor of committee of the whole amendment number 1, please stand. All the Thank you. All those opposed, please stand. Thank you. 26 to 29, the amendment has failed. Back on the bill. Further discussion. Representative Northrup.
Thank you, Madam Chairman. Can somebody just tell me what these chips do? Are they going to track you? Or are they going to follow you around? Because I got a bunch of cows I know that I'd like to know where they are all the time, and that'd be a great use for these chips.
Penn?
Thank you, Madam Chairman. So in committee, we heard testimony from individuals representing employees, and they were in favor of this bill, saying that we can't have a bill that allows employers to invade the personal lives of our employees, and microchipping would invade people's lives. So we may not have this technology being used in Wyoming, but it's certainly being used around the country or around other countries. There's a country who is named after meatballs that uses it a lot. Is it forced in most places? No, but we've seen in the last about 3 years where a situation which didn't exist was very rapidly forced upon people to do things to their body that they didn't want to do in order to remain employed. Situations where maybe one employer began requiring something and it was easy at that point to say, oh, well, you can work somewhere else. But when another employer and another employer in rapid succession becomes that way, then people find situations where they can't be employed without submitting to requirements that things be done to their bodies against their will. And so I think this is a perfect opportunity to have these discussions when we aren't experiencing the mind fog of fear and things that often come with situations that may arise in the future. 12 other states currently have this type of legislation in place, and some of those states go much further than what this bill does as far as what cannot be allowed. So I think this is a very reasonable start to this approach. I would urge an aye vote on this bill. Thank you.
Representative Ottman.
Thank you, Madam Chair. Just to step back for a second, I was employed for a governmental place for 15 years. About 9 years into that employment, it was required that we had this little machine and that we put our finger on there. They wouldn't take our time cards anymore. We actually had to get, although we had background checks and all that stuff, we had to put our finger on this thing to read our fingerprints. And if we chose not to, they said, okay, fine, you will not get your paycheck. And it was that flat out. I couldn't believe it. And so on the days when you're cold, or the days that different things are going on, your finger doesn't work, or the thing has hand cream all over it, it was a train wreck. 3 years later, they quit all that because they said it is too hard to implement, to keep going. It doesn't make sense. It took a lot more bookkeeping than we thought, but nevertheless, all of our fingerprints were in there because it was a requirement to get paid. It was an invasion of my privacy, and it was overreach of government. But nevertheless, in order to keep my job, which I loved, and in order to get paid, I needed to do that. That is why we can be proactive in stopping something like this, because it is in this country, and it is becoming a tendency. We have all of these companies we're bringing in. We want the manufacturing. We want the national companies and the international companies. A lot of those places already do this. So I would just ask you to vote aye on this. It's not a big deal. It just says we are not going to allow people to mandate that our citizens have microchips put in their bodies. Thank you.
Representative Davis.
Madam Chair, out there in the industry now, we use these tracking devices on all the vehicles that are out there. So you know if you've been naughty or nice and where you've been, but they're not very foolproof. I mean, if you're sitting there in a snowdrift and you're spinning your tires trying to get unstuck, you get a black mark on your chart. So, I mean, this is almost seems ludicrous to me. Now, chips, I use them on my racing stock, but last time I checked, we aren't livestock. So I'm not really sure where I'll vote on this one.
Representative Singh.
Thank you, Madam Chairwoman. I think what the previous speaker had to say was spot on. We aren't livestock, and because of that, we're in such a position to nip this before it becomes a larger issue facing our citizens. It's a chance to be proactive in protecting the rights of our citizens, and for that, I believe that an aye vote is appropriate. Thank you.
Representative Yin.
Madam Chairman, so I agree. If companies were doing this, that would be bad. But again, 0 companies in the United States are doing this. What companies are doing they are tracking their employees. They're just not doing it with implanted microchips. So the question, I guess, is why we would adopt this bill instead of working a bill that allowed for prohibiting tracking of employees, especially employees outside their workplace. And I think that is a bill that we could talk about, but this one is one that doesn't do anything, and it doesn't stop anyone from doing anything because no one is doing it. So thank you, Madam Chairman.
Do you want to go? Representative Trujillo.
Thank you, Mr. Chair. I don't think the problem is the tracking per se. It's the point of putting something in your body. companies track, we're tracked on our social media, on our phones every day. The problem is having a company require you to put something in your body that you don't want. That's what we're talking about today.
Representative Locke, bring us home.
Thank you, Madam Chairman. So let me just talk to a few things that were mentioned out here. People wanted to know what's the technology. Well, I think most of you know the technology is far beyond tracking. Let's start there. It's far beyond tracking. This micro technology has the ability to monitor your health, to monitor all kinds of things, way beyond tracking. So technology-wise, that's what we're talking about. Now, the question is, what's the real problem? Well, there are companies out there using this technology already. People are taking it willingly, for the most part. It's not being forced. But it was mentioned earlier today that we have seen what fear can do and what fear can impose that will cross that individual liberty line. Okay? And so this is just an attempt. I'm going to go back to that. It's just an attempt. Again, it's not to keep a business from tracking while a person's at work, making sure they know where you are from the tracking, where you are with your vehicle. It's not looking to block that. But this is a situation where, and people are starting to understand this, and I think a lot of people take this technology and don't think about it, but once they take this technology, and to go to the last speaker's discussion, now it's something invasive. It's demand. We're blocking just the right to demand you to put this in your body, right? But now that it's in there, they're not just tracking you while you're at work. They have the potential to track you outside of work. And at first you say, what's the big deal? It's not a big deal until some agency, some government decides that for some reason it is a big deal that you get tracked. Okay, and you tell me the company that's going to try to block that. Those companies are few and far between. That being said, and I would go back to the speaker from the west side of the state, from the place of the tall mountains. He makes a great point. I disagree with him from the perspective that this bill doesn't have a place or doesn't do anything. It absolutely does. It makes it to where this cannot be mandated and forced. This invasive capability cannot be mandated. On the other hand, I don't disagree with him. I would gladly work with him on a bill that made sure that when you're outside of work, you can't be tracked. I agree with that completely. That all being said, and so the problem, we're getting in front of a problem that you could see happening if you go back to the last medical event that we had. You can go back and see what can be forced and what fear can do to drive us to mandate things that are potentially very invasive to the individual. So again, this is simply designed to in defense of this individual freedom and to make sure that the businesses don't have the ability to track. And quite honestly, the one thing that we've got to always remember, anytime the government decides that, well, we really can't do this to the individual, they have proven that they are very effective at pushing through the businesses to force it down to the individual level, because people will do things when their job is at risk. So I strongly ask for an aye on this bill. I think this is a great protection for the people of Wyoming. Thank you.
Representative Provenza, did you want to? Okay, any further discussion on the bill? Question being called. All those in favor of Chairman Zwanitzer's, correct, motion that when the committee of the whole rises to report, it do so with the recommendation that Senate File 72 do pass, say aye. Aye. All those opposed, no? No. Senate File 72 has failed committee of the whole. So pursuant to rules, pursuant to House Rule 6-6B, the bill having failed a voice vote, a standing division is required. All those in favor, please stand. I didn't. It's clearly for, yeah. Those opposed, please stand. Up, I did. Those opposed? Less than 38. Senate File 72 has passed the Committee of the Whole. And members, I just wanted to tell you, I don't know if it's up on our screen yet, but there has been a couple changes. So just be refreshing and looking for that updated list.
Madam Chairman, there's a rule that allows me to explain my vote. Oh, Rule 12-7, and so pursuant to Rule 12-7, I'd like to explain why I voted no on the bill.
Please proceed, Representative.
Madam Chairman, so we can have bills that do lots of things that we don't like. We could have a bill that required an employer to not require you to require you to cut off your hand. So we could have a prohibition on requiring you to cut off your hand for it as an employer. I think it's bad policy to pass bills that don't happen. And so that is why I voted no. Thank you, Madam Chairman.
The next bill for our consideration is Senate File 101. The reading clerk will read the bill.
Senate File 101, sponsored by Senator Ide. Wyoming Legal Tender Act amendments, an act relating to the Wyoming Legal Tender Act. Mr. Speaker, your committee number 3, Revenue, to whom is referred Senate File 101 engrossed, Wyoming Legal Tender Act amendments, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Bear, Byron, Harshman, Locke, Northrup, Oakley, Storer, Strzok, Swanitzer. Representative Harshman, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Harshman?
Thank you, Madam Chairman. I move when the Committee of the Whole rise to report, to do so with a recommendation that Senate File 101 do pass. And Madam Chairman, there is a standing committee amendment, but I think we'll wait on that after the explanation of the bill. And I would turn the bill over to the good co-sponsor from the land of the big tower. Thank you, Madam Chairman.
Majority Floor Leader Nyman.
Thank you, Madam Chairman. Ladies and gentlemen, I bring you Senate File 101 and would ask for your favorable consideration. Ladies and gentlemen, this is what we have here is the Wyoming Legal Tender Act amendments, act relating to the Wyoming Legal Tender Act. What this basically is, ladies and gentlemen, this is a piece of legislation that is an ongoing work that was actually brought by a good representative that is no longer with us, Roy Edwards. And this was part of his start at allowing the state of Wyoming to be able to accept gold or other precious metals as legal tender. And what we have here, there's a standing committee amendment that's going to come that is going to, pretty dynamically change the bill here a little bit, but I will give you a brief overview of it, and then we can go into that amendment. What you have here, and I'll just read the setup or the preparation for the bill. It's an act requiring the state treasurer to provide for the payment of mineral taxes by specie. And for those of you that don't know what specie is, I can give you a definition of that. Specie is a coin or having gold or silver content. So what we're talking about here is precious metals, being able to basically pay the state of Wyoming in precious metals as opposed to just paper or coin currency. Reading on down through what we're talking about here is requiring the state treasurer to determine and provide exchange rates for specie and specie legal tender, requiring the state treasurer to exchange these specie and legal tender for other legal tender currencies, and requiring the state treasurer to invest these said specie tender, and authorize the state treasurer to hire consultants to be able to deal with this as these precious metals are used to pay these bills. On page 2 of the bill, we can go on in, and we're going to be creating a new subsection, Wyoming Statute 9.4.1306, to read, the state treasurer shall implement the Wyoming Legal Tender Act by authorizing the use of said specie and legal tender for the payment of mine product. What they wanted to do was refine it down to just one particular way or opportunity to be able to pay this in an effort to try to get a start. not throw it wide open, but to give us a chance to see how it works to begin with. That was the effort in beginning at line 9 through line 14. Beginning at line 16 is determining, maintaining, and publishing a market-based exchange rate between specie and specie legal tender and other legal tender currencies on a real-time basis to be able and have a website of the state treasurer for the purpose of calculating tax payments to or from the state. State treasurer may hire a consultant, which is a third party that they could utilize to be able to handle this process, and determine the exchange rates under the paragraph, and do this in actual real-time basis, meaning as close as possible to the actual time that the exchange information is available, so that the information is provided practically and immediately. Romanet 3, exchanging the specie legal tender for other legal tender currencies, and Romanet 4, which is actually going to be discussed in the Standing Committee amendment, holding specie and specie legal tender. Romanet 5 is the market conditions warrant investing the precious metal leases or bonds payable in precious metals. And then moving on down, this is where the contracting takes place, ladies and gentlemen, from line 13 on page 3 down to the bottom of basically 23. It says the state treasurer may contract for services with established precious metals firms and other industry experts to assist with the duties of the treasurer under this section. State treasurer shall require background checks and financial disclosures along with any other requirements specified by the state treasurer prior to engaging in any contract under this subsection. And then going on, it says state treasurer shall adopt rules necessary and they can implement or promulgate those rules. On the last page of the short bill, page 4, section 2, it says the state treasurer shall then adopt rules necessary to implement this act not later than January 1st of 2024. Now, the Standing Committee amendment you're going to hear about here briefly in a moment is going to have some pretty dynamic changes to this, and we can discuss that when it's read in. But that's basically it, folks. At section 3, it says, except as provided in subsection B of this section, this act is effective immediately upon completion of all acts necessary, and it would be law and would allow our state treasurer to be able to take legal tender, gold, or other precious metals for payment for taxes. And with that, I would try to answer any of your questions.
Representative Newsom.
Thank you so much. I believe that gold is a commodity and that all these precious metals are a commodity. So why wouldn't we allow other commodities? Say, why don't we take a barrel of oil for our taxes? Why don't we take a ton of coal? Why don't we take 40,000 pounds of pork bellies in payment for taxes? Because they're a commodity the same way gold is commodity and the same way that silver is a commodity. So I would resist the notion that we should take commodity pricing for the payment of taxes. Thank you.
Majority Floor Leader Nyman.
Thank you, Madam Chairman. Thank you for the good questions. I mean, when you ask those questions, good representative, I was trying to imagine somebody driving up and trading pork bellies for their taxes and where they would put them for a freezer. But I think what's trying to happen here is gold is a standard we used to stand on in this nation. And gold has a value that is current and is easier to handle, quite honestly, than many of the other items that you said, you brought up there in the commodities. Being able to put a current value on those as well, and to be able to hold those and to be able to trade with those. A lot of folks carry gold and other precious metals, and they do have a value, and it allows our state the opportunity to be able to trade in those commodities and allow people to be able to take advantage of increasing values of those precious metals. And that's where we leave the third party to be able to determine those values and invest or sell or trade those immediately, thus giving people multiple options to be able to have more stability as we see our dollar struggle, and many times some people are concerned about where it's headed. This is simply allowing for more options and giving people more opportunity to be able to utilize some things that they already have and enjoy that increase in their value.
Chairman Washut.
Thank you, Madam Chair. I'm just trying to wrap my head around this. I'm thinking, if I had to pay my property taxes, would I rather pay my property taxes with dollars or get some of the precious metal out of my safe deposit box and go down and pay my taxes? What incentive is there for a minerals company to want to pay their taxes in gold as opposed to dollars? And are there any mineral companies interested in doing this?
Majority Floor, oh, Speaker Summers.
Madam Chairman, thank you. On and against the bill. Gold, the dollar bill is less volatile than gold. I don't understand this. I don't understand why it's good policy. We can invest in gold as the state of Wyoming right now if we want to. We don't have to have this bill. And so what is the reason to allow a company to pay their severance tax with gold? How does that advance the policies of the state of Wyoming? What does this do does this in fact help some gold trader? Does it help some gold trader out there that wants to trade gold for a price? Is that who this helps? Because I'm struggling understanding why this bill helps the state of Wyoming or frankly anything.
Representative Ward.
Thank you, Madam Chairwoman. So the point, I'm on and for this bill. The point of the bill is to hold gold as a hedge. Paying taxes is the minor part. We physically need to hold gold by our state treasurer so that we protect ourselves against inflation. It will be an insurance policy to protect the Wyoming taxpayer. Please vote aye.
Majority Floor Leader Nyman.
Thank you, Madam Chairman. To go back and answer some of the questions that were posed, I guess it's just the opportunity to be able to give somebody, and the question of the first good representative from the county number one. To me, as I try to kind of wrap my mind around this, I mean, my name's on the bill and I do support this option. If that's something that you've invested in and you have that opportunity to be able to trade in that, then to me, it makes sense that you would be able to have that opportunity, that option. If we've got positioned in place as far as our treasurer or the entities that could be able to trade in that, I know a lot of folks that are very unconvinced that our dollar is holding its value in accordance to what gold and silver and the other precious metals are doing. So it provides them a wider opportunity to be able to sell or to trade or to invest. And then also to me, I will push back a little bit on the statement that, the dollar is more stable than gold. I mean, if inflation is any indication of what we're dealing with right now, my dollar ain't worth a great lot. And as we watch our dollar fall and gold increase in value because it is a limited supply, and we watch inflation rates as we print dollars in exponential amounts, I can understand why people would want to look at this as an option, to be able to have something that's more tangible and is something that is more stable. A few points to be brought out in this. Since legislation was first proposed back in 2019 to prompt our state to hold gold prices in dollars has risen by 50%. We did not pass any of the proposed bills, but sadly today the state still owns no physical gold or silver, none. And so those are just some things that we need to consider. And I think what this piece of legislation is doing is, in my mind, is just allowing for an option. And I think the standing committee amendment is going to kind of dynamically change this particular bill, but it still offers a framework to be able to work within to offer that opportunity if people would so see fit. And so, I often say freedom is choices. And so if the ability to be able to do this and to have that and the leverage of that and the ability to invest in that and utilize those increases, and the state cannot be or if the state has the opportunity to not be damaged by this, but to be able to invest and even grow with it, I think it's something we really do genuinely need to consider as a legislature.
Chairman Nicholas.
Thank you, Madam Chairman. On and against the bill, ladies and gentlemen. So right now, we have the ability to trade in gold. You can go to the stock market and you can buy gold basically. Right now, I can get on my computer and buy all the gold I want, but it's a paper asset for someone else that holds the gold for you and does all those things. So when this bill came up in 2019, we had numerous folks come testify in our committee, and including our chief investment officer. If we want to invest in gold, we can do it, and it costs us nothing other than the cost of the trade. And then you can reap the benefit of the increase in value over time. But what you don't have to do is have a vault, have a security guard, and worry about all the issues of holding the gold in your hand and have a hard asset that you've got to take care of, you got to pay for, and do all those things. If you back all those costs out, you actually make a lot more money if you simply trade in gold or aluminum or silver or whatever those products are. And it's an open market, and I actually own some of these stocks that are basically invested in gold, and so it's a simple thing to do. So, but does it make sense to actually accept gold and weigh it and measure it and test it and make sure that the quality of the gold? I would just suggest that it's not economically reasonable to do it that way. So on and against.
Representative Bear.
Thank you, Madam Chairman. So on and against the amendment and for the bill, I was in the committee when this bill was debated, and I just want to clear some things up. The good chairman of appropriations is right. You can purchase paper and trade in that, and it's a pretty simple way to do it as far as gold is concerned. But this bill is not about that. This bill is not about trading short, trading long, trying to make an extra buck on gold. This is about holding gold, as the good representative from the center of the state said, in a hedge against inflation. So this bill, without the amendment, simply creates the framework. And one of the things you'll see in the bill is it talks about contracting for services for things like determining if it's truly the value that we expect it to be. The good chairman of appropriations talked about the cost of holding gold, including guards and all the infrastructure, the things that you need. And back when this was first discussed, I think he said 2019, I'm sure that all those things were an issue, but something is coming to light, and it came to light just this last week. We have a corporation, and granted it's only one, but maybe there'll be more in the future, that is opening up in that city in the center of our state as we speak. They're building what they call Fort Knox in Wyoming, and they take in raw materials that are the commodities that were discussed by the good chairwoman of TRW. So what is the advantage we get there? We have, or may have in the near future, all of the things that are necessary to make this work. And this bill is simply setting up the infrastructure and getting the treasurer to a point, that elected official that takes care of our money, gets him in to go ahead and move forward with the things that are required so that we can do this. It does require that we hold some precious metal, but it doesn't have a quantity. Many of the states that have passed a similar bill, and boy, this is happening all over the country now, they put a minimum of their holdings. For instance, several states have 1% of their holdings have got to be in precious metals. There is no such minimum in this bill. So in other words, we could purchase 1 ounce of gold or silver, and that would be sufficient to satisfy the bill. The bill is really about creating the infrastructure so that we can, should an opportunity come to us, and should we need to do it. And certainly, as our federal government continues to print money and devalue the dollar, this may be something that we need. And I point to the central banks all over the world and what they're doing. They're purchasing gold right now. So this is something that others see as a concern, not just those who see black helicopters all the time. So I would advise a no vote on the amendment and hopefully an aye vote on the bill.
Representative Jennings.
Thank you, Madam Chair Lady. So for me, it comes down to a couple of things, and I've been on every bill, I think, of legal tender since its beginning back in those days when the good chairman of appropriations was talking about. Listen, your dollar wasn't the constitutional specie. Precious metals was. And we changed that over time. And so as I look at this, this is more about freedom. It's about the opportunity. There's the last speaker talked about the opportunity for jobs coming to Wyoming. And I think that's a great thing. But it's also about freedom for the individuals. Somebody going to go pay taxes with a pocket full of gold? Probably not. What if they wanted to? So there's some freedom there that's, that that we're in this body are sent here to protect people's freedoms. Now, the pork bellies and things like that, maybe if they would do bacon, I would do some trading with them, precious metals or something there, but catch it in between, be a middleman. Those things are not constitutional. The commodities aspect of that is not the constitutional aspect. Precious metals was. That's what this nation was founded upon. And so it makes a statement. It gives an opportunity for jobs coming to Wyoming, and it gives freedom to our citizens. On and for the bill.
Representative Locke.
Thank you, Madam Chairman. And just a couple of things. Wyoming, I think this might have been said, but I might have been out for a second. But Wyoming currently has very good sound money laws. And as all this does, as one of the previous speakers just said, this just enhances that. Again, it doesn't put limits. It just continues to take us farther down the path of enhancing our sound money laws, which is very attractive. To quote many people who testified in committee, no fiat currency has never not deflated to zero, right? And when you look at call it inflation, call it deflation of the dollar value to gold, there is potentially value to doing that, to having that precious metal as a hedge. Again, this is just put the mechanism in place, gets us started down the path of, then gives us opportunity to look more at this as the world progresses. One other thing that I think was said a little bit, but I want to throw out there, at this point in time, a lot of companies, banks, other organizations are starting to put precious metal on their balance sheet. They're doing this more and more. And there's some big companies who've done this already in fairly major chunks. So that's just something to keep in mind, that it's just an option. But if it does nothing else, it at least gets us moving down the path of enhancing our path to having a rock solid sound money process here in the state of Wyoming, which I do know to many companies, many organizations out there, that's a very favorable business environment for them to move into. So I'm against the amendment and in favor of the bill.
Chairman Harshman.
Thank you, Madam Chair. Sensing you're ready for me to move the Standing Committee amendment, Madam Chairman, I'd move Standing Committee Amendment Number 1 to Senate File 101. Explain the Standing Committee amendment, then I'll ask for your aye vote. Okay, folks, this bill, let's summarize, it really does two things. And if you look at the original introduced bill, it required your county treasurer to accept property taxes as well with specie. That was amended out in the other body. So then it comes to the state to pay severance taxes. A little bit of problem in here because the elected office number 3 downstairs does not collect taxes, right? That's when the department, I don't think I can say it, but the department begins with an R, right? They collect the taxes, they collect severance taxes. So we listened to all the testimony, your Revenue Committee number 3, and so we had to try to think about this problem of how you pay your severance taxes to the treasurer. Or excuse me, I shouldn't have said that. To the office number 3 downstairs. So we couldn't really figure that out, so we got rid of it. That part got deleted out of the bill. Paying your severance taxes to department number 3 is out. And then we looked at, on page 2, on line 6, if you got the bill, page 2, line 6, it says the state treasurer shall implement the Wyoming Legal Tender Act by doing these things. Okay, so the first one is Romanet 1, 9 through 14, get the severance tax paid. So we deleted that. Then we left determining the Romanet 2, maintaining these market-based averages. So that's in there. Then you flip over to page 3. We left exchanging specie and specie legal tender and other legal currencies. We left that Romanet 3. We took out Romanet 4 just because holding specie, and I know the proponents say, hey, you could buy one gold coin and do this act. Well, I don't think that's the intent. I mean, the intent is really we want, if we're going to hold it, then it's going to be in a different deal in a facility like what's in Casper, right? And these facilities are in Utah, and they don't do this for free, obviously. They hold that for a profit. But, and then we, Romanet 5, we left in there as well. So, and then I think we left paragraph B, we renumbered that, and then we put in there the state treasurer, and we put the Department of Revenue can work on rules. We put the implementation on section 1 of the bill back to 2025. So really, so the criticism of this amendment is that it really, as a good majority floor earlier said, I think substantially, or he had an adjective, changes the bill. I think two things. The big parts are we took out the payment of taxes, and we didn't tell the treasurer, you shall do this. We said you may do this. I think that, I think that might help the bill because folks don't be like downstairs, they have this issue of us up here telling them shall. And then finally, that office number 3 does not invest for us. They work the plan developed by all 5 of the electeds. That's called the SLIB board, State Loan Investment Board, those 5 elected officials. And that SLIB board, that is a creation of the legislature. That's not in the Constitution about the SLIB board. So we created that, and we want them, the majority, 3 out of 5, to vote on, a portfolio of how we invest the state's wealth. So they can do this already if they choose to. But as far as paying your taxes and speed, then you've got to hedge it, you got to hold it, you got to make sure it's right on that day. I think maybe someday we could probably do that. I just don't think we're there yet. And I don't think we want to spend the time, money, or effort to do it for something that we never heard one mineral company come forward and say, hey, we want to do this. So I think you can pass this standing committee amendment. It takes this bill down a little bit, about as much as the other body took it down. The other body whacked it pretty good too. I should say refined it pretty good too. And I think we could refine it a little bit. And even with that, it still sends a little message, right? Because everything we say at the mic and everything we say in bill sends a little message. Now, this would be a littler message, but I think the entrepreneur that's coming into my hometown, it's pretty cool. It's a pretty awesome deal. And they're a proven company, and they've moved here to Wyoming because of our business-friendly tax climate and because of Casper is an international trade zone. The airport that we just voted to build a new tower for, although we didn't say it was them, that airport has generated this business. And so it's pretty amazing. And that's what the owner told us on the tour of this, is so, as they looked around the country where to relocate. So, but I think the amendment doesn't destroy the bill. It refines it a little bit, takes out some of the clunkiness of it, but I think the message is still okay. So I'd encourage your aye vote on the amendment, and then we can vote aye on the bill. I don't think it hurts a thing then. I think it sends a message that we're still open for business in this area, like we have with cryptocurrency and the blockchain. Those are important messages when we keep talking about it. So with that, I urge your aye vote, and I'd call for the question on the standing committee amendment unless there's further discussion.
On the discussion on the standing committee amendment, Representative Jennings.
Madam Chair Lady, I'd like to divide the amendment. I'd like to divide lines 1 through 8 and 10 through 26 and line 9 separately. Only 9 is the only one I'm wanting to speak to.
Okay, so just to clarify, so Division 1 being line 9?
Yes.
And
Madam
Division
Chair,
2
I-
being the rest of the
Yes,
amendment?
ma'am.
Okay, give me 1 second. It appears to me to be divisible, but I would
No,
like
no, I'm only doing
stand
this.
at ease.
I'm changing the shall, the may back to shall. So I want to make sure we get. That further, I don't care.
The chair finds that that is divisible.
Madam Chair.
Chairman Harshman.
Thank you, Madam Chair, and I appreciate the division. I just want to make clear that line 9 is just division number 1. The rest of the bill is division number 2. And so with that, Madam Chair, I'd like to further divide division number 2, and I'd like to make lines 1 through 5 of the amendment, division 3, and lines 11 and 12 also division 3. And that is the paying of taxes. I think that's a separate issue, and you divide that out. So, Madam Chair, that current one by the previous speaker, that Division 1 is on line 9. And then Division 2 would be 6, 7, and 8, and 13 through 26. Division 3 would be 1 through 5, and 11 and 12. I think that works, and I think it gets to all the issues. Aren't these standing committee amendments fun? They're complicated, so we got to work them out. So, thank you, Madam Chair.
So Chairman Harshman, lines 22 and 23 need to be included in Division 3. Do you agree?
Thank you for your correction, Madam Chairman.
And then with that, it is divisible. And so which division would you like to take up, Chairman Harshman?
Madam Chair, I think we start with number 3, which is the payment of taxes. And again, Madam Chair and members, that's lines 1 through 5, lines 11 and 12, and as you corrected, lines 22 and 23, because we don't need to have, if we remove this payment of taxes, we don't need to have the Department of Revenue adopt rules. Okay, and I think we want to debate that some more, but I think it's just, I just don't think it's going to happen. I don't think we're set up for it, and I don't think we want to do a bunch of administrative jujitsu and have to hire consultants, et cetera, for that. So that's that. I would encourage your aye vote on Division 3, which removes the payment of severance taxes. Thank you.
So discussion on Division 3. Representative Bear.
Thank you, Madam Chairman. I would like to further divide division number 3 to be just lines 25 and 26 as as division 4. Lines 25 and 26 to be division 4. Part of 2.
So at this point, I'll rule that out of order. We're on Division 3. So we can take that up later. So back on Division 3. Seeing no further discussion, question being called? No? Somebody? Question? So you've heard the motion on Division 3. All those in favor say aye. Aye. All those opposed? Division 3 has been adopted. Chairman Harshman?
Madam Chair, I think we probably move on next to just Division 1, which was that one word on line 9 from shall to may, directing the statewide office number 3 downstairs, moving from a shall to a may, and so that's Division 1. And I, of course, as the chairman of the standing committee, would encourage you to vote aye on the amendment on Division 1. Thank you.
Discussion on Division 1, Representative Storer.
Thank you, Madam Chairwoman. On and for the amendment, it's just important to remember that our treasurer and our managers have a fiduciary duty to do the best they can when it comes to investing our permanent funds or our other assets for the state. And I think the idea of hedging against inflation makes perfect sense, but you really want to look at how you can best do that with the least amount of cost. You can buy gold shares, you can buy gold ETFs. They are sometimes tied directly to physical gold in specific ways. And if you go that route, you end up paying, a fee to the fund. Sometimes it's usually less than 1%. If you're buying physical gold, you will have to pay dealer commissions, you'll have to pay sales tax in some cases, you'll have to pay storage costs and security considerations. And while there's nothing to say that that might not be a good idea, the possibility that that could be more costly to the state than just buying an ETF gold share is possible. So we want to give the treasurer the option of doing this based on those costs. And that's what this amendment does. So on and for the amendment. Thank you.
Discussion on Division 1, and Representative Jennings.
Yeah, Madam Chair Lady, the reason that I divided out this one has to do with stability. And so there is company businesses that wants to come to our state and do business. And we all know that businesses, they want stability. They don't want a may. They want to know that this is going to transpire, that there is an actual market here for this. And so even in the realms of government, we all know, we all sit in those committee rooms, we all understand that they want stability. And so even our office number 3 downstairs, we send a shall and we send a may. One provides the stability and the other one is just not certain. And so in my conversations with them, the reason that I divided this division number 1 is to provide that stability to office number 3 and to the businesses that would like to come to this state. So vote for Division
1.
Vote no on Division 1.
Representative Hornock.
Thank you, Madam Chairman. I also would ask for a no vote on Division 1. It seems like if we're going to pass this law, we should want them to pass it. And I will remind the body that the office that deals with this that we're talking about, as well as us ourselves, stand in a building where the dome is covered with gold. It's kind of ironic, don't you think, if we don't insist on something like this? And just look throughout this room, there's gold painting throughout the room because it is significant. That is a significant commodity. It's not oil, it's not pork barrels, it's not coal. This is a very significant commodity. I think we need to do something with it. And I think that shall is important to leave in there. I would urge a no vote on this division.
Speaker Summers.
Madam Chairman, thank you. On in support of Division 1, once again, why are we trying to mandate the purchase of gold species so and basically jeopardize our investment strategy so some business can come here and sell gold species in the state of Wyoming? Makes no sense. Why don't we mandate that they buy cattle? Why don't we mandate they buy wheat? Why don't we mandate they buy any other commodity in the United States or that's grown in this state? Why would we do this? On in support of the amendment. The Division 1.
Representative Ward.
Thank you, Madam Chairwoman. On and against Division 1, it negates the point of the bill. Senate File 101 gives us the state treasurer the tools to deal in monetary metals so the state is better prepared to protect itself from inflation and financial turmoil. It permits the treasurer to hold a portion of state funds in physical gold and silver, and if market conditions warrant, the treasurer could invest in precious metal leases or bonds payable in precious metals. Wyoming has been a sound money leader among the states since its passage of the Wyoming Legal Tender Act in 2018. The next logical step is for the legislature to pass SF 101 without Division 1 to enable the state to hold and deal in constitutional sound money. I urge a no vote on Division 1.
Any further discussion on Division 1? Chairman Harshman?
Yeah, thank you, Madam Chair. Just to wrap this up, I think it's important that that one office, number 3, does not invest willy-nilly on what that current office holder or any future current office holders. That is a very important decision that goes through an investment funds committee and the SLIB board, the top 5. So it's not in the hands of one person. I'll say this about the stability piece that was brought up. Their customers in Casper, they're international customers. This is a big deal. It's not way bigger than anything the state is going to do. And part of what the message was already sent with the Legal Tender Act that this body passed a few years back. But that shall may thing, because we're not even a light bill. We're not even a part of that. This is a different business for different customers, not governments doing that. So I would just say that's my deal on that. So I think passing amendment number 1, then we can continue on with this bill and send a good, clear message. So thank you. On in support of Division 1.
Further discussion on Division 1, Representative Jennings.
Thank you, Madam Chair Lady. And I think the good chairman just kind of made my point. I think that's exactly what we want to do. This isn't about, hey, we're going to buy a boatload of gold, or it's not about that. In fact, that's why that lower end of that is not in there. It's not that we're going to turn in everything that we've invested in and go buy gold. But it does say to the people of Wyoming and to these businesses, we're the legislature, and we ought to have a little bit of buy-in that just says, yeah, we do this too. We believe in species that was constitutionally mandated for 120 years before we ever moved off of that. And now there's a lot of states that are trying to move back, and this Division 1 says that Office 3 will at least make a little bit of a token statement to people. Hey, we're in Wyoming, we're in business, we believe in this also. And so I'd ask you to vote no on Division 1.
Ready for the question? Question having been called, all those in favor of Division 1 say aye. Aye. Opposed, no? No. Division 1 has been adopted. We're back on the bill. Division having been called, all those in favor of Division 1, please stand. Opposed, please rise. Division 1 has been adopted, 3326. Chairman Harshman, would you like to speak on Division 2?
Madam Chair, I think we could vote aye on Division 2, and then the bill is in pretty good shape, I think. So I urge you, I vote. Thank you.
Further discussion on Division 2? Question having been called. All those in favor of Division 2 say aye. Aye. Opposed, no? No. Division 2 has been adopted. We're back on the bill. Division having been called, all those in favor, please rise. All those opposed, please stand. Division 2 has been adopted, 3426. We're back on the bill. Representative Larson.
Thank you, Madam Chairwoman. So I'd just like the body to consider this. I was looking through our Wyoming Constitution, and I'm looking at Article 15, Section 7, and it doesn't prohibit the use of specie, but I think the original intent of our Constitution was for legal paper money. And I'd just like you to consider that when you're making your vote.
Representative Davis. I called on you, Representative Davis.
Thank you, Madam Chairman. To me, this bill isn't about industry or any of that. It's about the small guy out there. Say the dollar does go to heck, okay? Then how will we pay our taxes? Okay, so if gold is available, or silver, or cows, or whatever, but if gold and silver are available, I would be able to pay my property taxes and not lose my ranch. So I think it's not exactly about industry here. I think it's more about the small picture here. So I'm in favor of this bill. It'll stabilize my existence.
So there is a committee of the whole amendment, correct? Would you like to bring that, Representative Jennings?
Chair Lady, I'd like to withdraw Committee of the Whole Amendment 1, or Standing Committee to Senate File 101. Respectfully withdraw it.
So you're withdrawing the committee of the whole amendment number 1. Thank you. So back on the bill, Representative Clouston.
Thank you, Madam Chair. I just want to share a story. I once had a patient and she wanted to pay her bill with a horse. I said, what am I going to do with a horse? And she said, well, you can sell it. And I said, why don't you sell your own horse and bring me what you owe me, right? So, but there's a question here of influence. Our country in 2020 produced 120 tons of gold. The two largest communist countries in the world produce 680 tons of gold. So we have to think about gold. We think it's very secure, but we're not the one that has the influence on the price of gold. So just something to consider in the economic factors. Thank you.
Speaker Pro Tem Stith.
Madam Chairman, thank you. Just on and against the bill. One of the things we all know is how volatile the price of gold is. Although the Standing Committee amendment makes the bill much better, nonetheless, this bill doesn't really solve a problem here in Wyoming, and the spirit behind it could cause damage. In March of 2022, the price of gold was $2,043. 6 months later, at the end of September, it was $1,628. It dropped 20% in value in 6 months. There's no point in introducing that kind of volatility into our system, so certainly into our system of tax payments. Again, the Standing Committee amendment makes the bill better, but the bill doesn't solve a Wyoming problem, so on and against.
Majority Floor Leader Nyman, you want to bring us home?
Love to, Madam Chairman. Thank you very much. Just one other thought here that I want to bring up for all of you before we close this out. Last year, the central banks bought more gold than they have in the last 50 years. Holding some gold would help the state of Wyoming hedge against a very high exposure to Federal Reserve note dollars, whose value has recently plummeted the fastest it has since the 1970s. So this is an effort to broaden what we do and how we invest. It's an effort to allow options, and this is a framework to be able to work within that. I mean, the amendments, sure, that's fine. If we can get a framework here that we can go beyond this, I appreciate the discussion. The discussion has been awesome because we are in a position right now, and we are seeing inflation at rates we have not seen in my lifetime. Well, actually, I shouldn't say that. I should go back to about the early 80s when people were paying 18% interest on land notes, and land and ranches were being lost, and people were trying to figure out how they were going to make this thing work. And we're headed that direction carefully. But I would just suggest that you would appreciate a support of this bill, even with the amendments on it, to be able to create a framework that we can use and build on and allow some choice. A gentleman told me one time, he says, you don't actually own it unless you can stand in front of it and protect it with an AR-15. Kind of a novel idea. And in the way that we are everything right now, it's paper or it's a stroke on a computer, and it can disappear as quickly as you got a hold of it. It's not tangible. One point in this is tangible. So I would encourage you to vote aye.
And call for the question? Okay, question having been called, all those in favor of Chairman Harshman's motion that when the committee of the whole rises to report, it do so with the recommendation that Senate File 101 do pass. All those in favor say aye. Aye. Opposed, no. No. Senate File 101 has passed the committee of the whole. Division having been called, all those, division having been called, all those in favor, please stand. Thank you. All opposed, please stand. $27-ish? Is that what'd you get? Okay. Senate File 101 has passed committee of the whole 3526. The next bill for our consideration is Senate File 167. The reading clerk will read the bill.
Senate File 167, sponsored by Senator Nethercott. Domestic Violence Protection Hearings, Remote Appearance, an act relating to domestic violence protection. Mr. Speaker, your committee number 1, Judiciary, to whom is referred Senate File 167 engrossed. Domestic Violence Protection Hearings, Remote Appearance. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Chestick, Crago, Haroldson, Jennings, Nemec, Oakley, Provenza, Rodriguez-Williams, Washit. Representative Washit, Chairman.
You've heard the reading of the bill. What's your pleasure, Chairman Washit?
Madam Chair, I move that when the Committee of the Whole rises to report, it do so with a recommendation that Senate File 167 do pass. And I turn over explanation of the bill to our good Judiciary member from Sheridan County.
Representative Jennings?
I don't have the bill. Yeah. Barry, you got it?
Representative Crago?
Thank you, Madam Chairman. Members, I bring to you Senate File 167 today and ask for your favorable consideration. Senate File 167 creates a provision in our statute that allows participants in domestic violence hearings to appear remotely. Right now, the courts are allowing that, but there's some question about whether or not they actually have the statutory ability to do that. There's lots of policy reasons why we do that. One is for protections of both sides of the case. Also, we have people that are sometimes out of state and they need to participate remotely, and so it's pretty simple, straightforward. Like I said, the courts are already doing it anyways. Following the pandemic, this was happening more and more, and so now we're just going to put it in statute. It's that simple, straightforward. Questions?
Question having been called, all those in favor of Chairman Washit's motion that when the Committee of the Whole rises to report, it do so with the recommendation that Senate File 167 do pass, say aye. Aye. Those opposed, no. Senate File 167 has passed Committee of the Whole. The next bill for our consideration is Senate File 76. The reading clerk will read the bill.
Senate File 76, sponsored by Blockchain, Wyoming Digital Asset Registration Act, an act relating to digital assets. Mr. Speaker, your committee number 2, Appropriations, to whom is referred Senate File 76 engrossed, Wyoming Digital Asset Registration Act. Respectfully report, same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Henderson, Nicholas, Sherwood, Stith, Walters. Noes, Representatives Wanitzer. Excused, Representative Larson. Representative Nicholas, Chairman.
You have heard the reading of the bill. What is your pleasure, Chairman Olson?
Thank you, Madam Chairman. I move that when the Committee of the Whole rises to report, that it do so with the recommendation that Senate File 76 do pass. I further move the adoption of the Standing Committee Amendment, and I will explain the bill and the Standing Committee Amendment. And when the time is proper, I will turn it over to the good Chairman of Appropriations to address their Standing Committee Amendment. So, folks, what this is a bill that establishes the Wyoming Digital Asset Registration Act, excuse me. It's simply a place to register your digital assets within the state of Wyoming. You can think of it like a trademark or a copyright because the user is seeking to protect their intellectual property by registering it and saying to the world, hey, this is my asset, I own it, and here it is. The reason why we need this bill is because the current position of the feds is that you cannot copyright a digital asset. So, because you cannot copyright it, we on the Blockchain Select Committee said, hey, what if we just created a repository in Wyoming and said, we're not saying you can copyright it, but we're saying you can register it here and and the world will know that your asset exists, and the world will know that it is in fact your asset. So that's the number one reason why you would want this bill. Number two, we want a registration act because we want to bring in people back into Wyoming who want to register their assets here. They would want to do it so that they could avail themselves of all of Wyoming's blockchain laws. So the over 24 laws that we've enacted over the last 6 years would be a reason why they would want to take advantage of the Registration Act. And then the last reason they might want to take advantage of the Registration Act is because in the bill, it very specifically provides jurisdiction to the Chancery Court. So if you have a registered asset on the Wyoming Digital Asset Registry list, and there is some type of a dispute, and I believe it needs to be over $50,000. If it's over $50,000, then you automatically have jurisdiction inside the Chancery Court. So that is the bill. On to the Standing Committee Amendment. The Standing Committee Amendment does a couple of things. When you register an asset, there is a registration fee. The registration fee is obviously in place so that it can be a self-perpetuating system and that it can pay for itself eventually. That registration fee in the original bill was $300 per registration. The Corporations Committee adjusted that from $300 to $500. The second fee that we adjusted is the re-registration fee. So every year annually, you'll have to re-register your asset. The original fee was $150, so it was half of the initial fee. We just decided to make that half of the new initial fee, that's $500, by ratcheting it up to $250. I'll take any questions on the Standing Committee Amendment.
Question having been called on Standing Committee Amendment number 1. All those in favor say aye. Opposed, no. Chair's in doubt, of which 10 people voted. So, all those in favor, please stand. We're going to count again. Please stand still and tall if possible. Thank you. All opposed, please stand. Thank you. Standing Committee Amendment number 1 has been adopted, 3324. We're back on the bill, or are we going to go ahead and go to Standing Committee Amendment number 2? Okay. Chairman Nicholas.
Thank you, Madam Speaker. Madam Chairman, I'll turn the good explanation. I would move Standing Committee number 2 to Senate File 76 and turn the explanation over to the good representative from Natrona County.
Representative Walters.
Thank you, Madam Chairwoman. So what the good committee number 2 did originally is on page 11 in section 4, we felt that our good agency number 2 already had the administrative abilities within their existing budget to handle this activity, and so we simply removed the $270,000 appropriation from the general fund to allow that good agency number 2 to do it with their existing funds. So with that, I would ask for your favorable consideration.
Further discussion on Standing Committee Amendment number 2? No further discussion, and question having been called. All those in favor, say aye. Opposed, no. Standing Committee Amendment number 2 has been adopted. Back on the bill, or are we going, does Chairman Nicholas, do you want to go to the Committee of the Whole Amendment number 1?
Yeah, Madam Chairman, I would move Committee of the Whole Amendment number 1 to Senate File 76, and also turn that over to the good representative from Casper for explanation.
Representative Walters.
Thank you, Madam Chairwoman. Upon further review, our good committee number 2 decided that maybe there was a need to have a little bit of money in this agency number 2 to administer some of this. And so what the Committee of the Whole Amendment number 2 does, we reduce the 270 down to 150, and then additionally another 20,000 for the purpose of the basically the office supplies and technology needed to get this up and running. And so again, that's a lesser amount than the original bill had, but there is some funding for that agency number 2 to administer this act. Ask for your favorable consideration.
Question having been called on Committee of the Whole Amendment number 1. All those in favor say aye. Aye. Opposed, no. Committee of the Whole Amendment number 1 has been adopted. Back on the bill. Any further discussion? Question having been called. All those in favor of Chairman Olson's motion that when the Committee of the Whole rises to report it, do so with the recommendation that Senate File 76 do pass, say aye. Aye. Opposed, no. Senate File 76 has passed the Committee of the Whole. The next bill for our consideration is Senate File 120. Reading clerk will read the bill.
Senate File 120, sponsored by Senator Barlow. Restoration of Civil Rights, an act relating to crimes and criminal procedure. Mr. Speaker, your Committee number 1 Judiciary, to whom is referred Senate File 120 engrossed, Restoration of Civil Rights. Respectfully report, same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Chestick, Crago, Haroldson, Jennings, Nemec, Oakley, Provenza, Rodriguez, Williams, Washit. Representative Washit, Chairman. This bill was re-referred to Committee number 2 Appropriations. Mr. Speaker, your Committee number 2 Appropriations, to whom is re-referred Senate File 120 engrossed, Restoration of Civil Rights. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Zwanitzer. Representative Nicholas, Chairman.
You've heard the reading of the bill. What's your pleasure, Chairman Washit?
I move that, thank you, Madam Chairman. I move that when the Committee of the Whole rises to report, it do so with the recommendation that Senate File 120 do pass. And I further move the adoption of the Standing Committee Amendment and turn over explanation of the amendment and the bill to the PhD in pink.
Representative Provenza.
Thank you, Madam Chairwoman. I guess I'm the PhD in pink. So today we bring to you Senate File 120, Restoration of Civil Rights. This is a wonderful bill, if I say so myself. So the purpose of this bill came from, several different things, but going door to door, and I'm sure many of you have run into this, you find folks that are like, gee, I'd love to vote for you, but I don't have the right to vote anymore because I have a felony on my record. And so what this bill does is makes it so that folks that have committed nonviolent felonies, have committed their time, completed their sentence, and have had 5 years elapsed since their completion, can get their voting rights back, their rights to be a juror, their right to run for office, and they also have their firearms rights restored. So in this, looking at people who have paid their dues to society, when we see that we restore their rights, we see that there's a beneficial impact, that folks are more likely to rehabilitate, they're more likely to be more ingrained in society, which makes them more successful in staying on that path of staying out of trouble with our department that oversees corrections. And of course, as much passion as I have seen in this chamber for firearms rights, I would imagine that some of you might believe that taking someone's firearms away from them is cruel and unusual punishment. So there's a lot of reasons to support this bill. I'll walk you through just real quick. There might be some questions that I'm happy to answer, but ultimately, with this standing committee amendment, which I hope you'll adopt, it makes this bill a lot easier to digest. So in the bill, you'll see there's some other statutes referenced. In the standing committee amendment, what we did was we fixed some of the language because it was taken out in the Senate side and it didn't cross over when we did the engrossed copy. So I think most, if not all of our standing committee amendment comes from just kind of a technical fix that was approved on the other side. And so what this does is it removes some language about domestic violence folks, people who commit domestic violence. That's a misdemeanor. There's issues with federal policy on that, but that's such a big and kind of complicated issue that we, the other body decided, let's kind of stay away from that. I think this deserves far more discussion in terms of policy. I would tend to agree. And in addition, it also deals with the governor's pardon issue. And that's another area in the bill where we're not necessarily trying to, maybe we don't want to meddle in that as much. We want to stick to this topic of we're trying to restore folks' rights if they're a nonviolent offender, they've done their time, and 5 years have passed. In addition, there will be some other amendments so on some of this language, so I won't get into the weeds too much now unless there are questions on it. But ultimately, most of the bill, making sure that we go back to this restoration of rights. And then you will see that there is a small appropriation on the last page. That is for the Department of Corrections to be able to just kind of complete this. We don't anticipate this being necessary as an ongoing appropriation, but a one-time appropriation should kind of get done what we need to get done. And then this will be effective July 1st of this year. So I will stand for any questions.
Any discussion? Representative Pendergraft?
Thank you, Madam Chair. On and for the amendment. On and for the intent of the bill, but against the bill, but we'll have time to get there. In watching the testimony on line 5, a good representative from District 13 suggested this amendment, and I believe it's a good one. Just a little tiny technical note, it probably should include a comma that's supposed to be deleted. We can clean that up later. I just wanted to throw that out there so we can detail that. Again, on and for the amendment.
Question having been called on Standing Committee Amendment number 1. All those in favor say aye. Aye. Opposed, no. Standing Committee Amendment number 1 has been adopted. We're back on the bill. And then do you want, okay, continue. Go ahead, Representative.
Thank you, Madam Chairwoman. At this time, I would like to move Committee of the Whole Amendment number 1 to Senate File 120. This amendment is just some cleanup language that we talked about in committee, but we didn't quite have it nailed down as terms of what exactly we were doing. This comes from the Department of that oversees our corrections, and what this does. So if you look on page 4, there's some language that goes. It's like line 17 through 19. We talk about if they've completed the person's sentence or completed a period of parole plus time equal to their sentence or 5 years. It's just a lot of cognitive backflips that you have to do to kind of understand all that, but it ultimately it makes our department that oversees corrections kind of have to jump through more hoops than necessary. So what this amendment does is it cleans up that language to make it just so that it's 5 years after the person has completed their sentence, and that's including periods of probation or parole. And then on page 5, we have a conviction for a new felony. So we're inserting, if you get in trouble again for a new felony, the issuance of any certificate under this section shall render the certificate void. And so that just means you get in trouble, you lose your certificate that says that you've had your rights restored. And that's just, you got to stick by the rules. If you end up in trouble again, then you don't get to continue to have your rights. And so I would ask for a favorable vote on this amendment.
Okay, just to be clear, we have some confusion up here at the front. This is Committee of the Whole number 2. Okay, we're on Committee of the Whole.
Mr. Chairman, I
Point of order.
apologize.
Oh, I just want to hear from Representative Provenza first. Go ahead.
Mr. Chairman, I believe I said the wrong amendment number. I explained amendment Committee of the Whole amendment number 2, which has my name on it, and that's what I mean to move. So I apologize. I did not mean to move Committee of the Whole amendment number 1. I meant to move number 2.
Okay, so I think that's where we're looking at your name, but you're talking about 1, I thought, and we heard 2. I just want to be clear. We're going to back up and we're going to go back to Committee of the Whole amendment number 1.
Thank you, Mr. Chairman.
Chairman Washington.
Committee of the Whole Amendment number 1. In the interest of time, I'm going to respectfully withdraw it today and bring it later.
Okay, now back to amendment number 2. Please move that and then let's get started. Go ahead. Thank you.
Thank you, Mr. Chairman. I apologize for the confusion. So this time I move Committee of the Whole amendment number 2 to Senate File 120 and ask for your favorable consideration.
Discussion on Committee of the Whole number 2. Heard a question. See no discussion. Okay, question being called on Committee of the Whole amendment number 2 to Senate File 120. All those in favor say aye. Aye. All those opposed say no. Okay, that amendment has been adopted. We are now back on the bill, but it's Committee of the Whole amendment number 3. Okay, backing up and moving out. Representative Chestick.
Thank you, Mr. Chairman. I move Committee of the Whole Amendment number 3 to Senate File number 120. And this is a little bit of a slight change in policy, but I have spoken with the prime sponsor and he's okay with this. So what this does is creates one additional disqualification for the restoration of gun rights. And it's in a limited circumstance. The bill as it's written says that after a felon has served his time and has for 5 years after that, he is can petition for the restoration of all of his civil rights, voting and other rights, including gun rights. But that's only applicable if that person has not engaged in another felony during that period of time. And if that person engages in a felony, they are not eligible to apply for the restoration of rights. This amendment simply adds another disqualification that if the person who has completed their sentence commits a misdemeanor involving domestic relations as defined by federal law, they have to wait 10 years. They're disqualified not forever, but for 10 years from getting their gun rights back. The rationale for this is that a conviction of anything involving domestic violence is something that creates a great risk to partners or other people that a felon might, if they had a gun, the risk to other people, domestic partners in particular, is enhanced. And we think that there's a very high risk of anybody who is engaged in domestic violence. If they have a gun, the domestic violence can get worse, can get lethal. And therefore, at the request of the domestic violence advocacy groups in Wyoming, we are proposing to have this additional disqualification if within 10 years after you have if you commit a misdemeanor of involving domestic violence, you have another 10-year wait before you can get your gun rights back. I would ask for your favorable consideration.
Okay, further discussion on Committee of the Whole 3. Representative Oakley.
Members, I would encourage a no vote on this. And as somebody who has spent a lot of time, working with domestic violence cases, and it is true that there's danger associated, lethality risk to women. But to me, this confuses what we're doing with this bill. This bill is about taking nonviolent felons and restoring their civil rights and maybe their gun rights. But then this then talks about this misdemeanor component about restoring their gun rights under federal law. And it isn't about restoring like their voting rights, because voting rights aren't taken away when you get a misdemeanor conviction of domestic violence. Anyway, it just doesn't fit to me. It's just a different component. So I would resist this amendment. I think it confuses the bill. If we want to discuss this, this needs to be done in I would say probably a separate bill, and also in a way that could be meaningful, because I don't think us saying this in Wyoming law restores their federal gun rights, and perhaps giving somebody like false confidence that it was restored, when I don't think that this can do that. So in the end, I think we've worked on this bill. It's a good bill. I would urge a no vote on this amendment.
Okay, any other discussion? Representative Pendergraph.
Thank you, Mr. Chairman, and thank you to the last speaker. I very much agree with her point. So much so to the point that there's a part of me that would like to call for the Rules Committee and ask for germaneness of this, but I'm not going to do that in the interest of time. I'm going to save you that and just ask you to vote no on this amendment. This may well be a good point, but it muddies an already very confusing, very hard to follow bill, and I think it's unnecessary in this place. Thank you.
Representative Hornock.
Thank you, Mr. Chairman. Not being an attorney, thank goodness, I'd like to know if there are any other situations where we take away somebody's Second Amendment rights when they do convict a misdemeanor. Thank you.
Other? Representative Ottman.
Thank you, Mr. Chairman. And I hope my comments are germane to this amendment or the bill, because I'm rather confused. What I'm wondering is, and I am not an attorney either, but it seems as though those that have pled guilty and been convicted of a violent felony here in Wyoming are prohibited from using or knowingly possessing a firearm. Okay, so that's for violent. So then to restore those rights, but if it's a minor felony, we have to get them convicted, or we have to reconvict them or something. What I'm wondering is is there a new penalty in this that removes their gun rights so that they can be restored? And so I'm just saying, the bill is very well intentioned, but it seems as though it's taking away rights to restore rights. I guess, I don't know.
Representative Provenza.
Thank you, Mr. Chairman. Just to clarify that question, because it is a good question. And in drafting this legislation, there are federal policies that take your gun rights away from you. Domestic violence being one of those, and that being a misdemeanor. The issue is that, and why that language was originally included in this bill, is because there's no path to restoring someone's civil rights unless the state has taken them to then restore them. So if we don't do anything about it, then under federal law, you don't get them back. But that language, I mean, originally in the bill in the other chamber was taken out. So, depending on how you feel on the amendment, but that's the reason why you'll see some of that language that removes is so that we can give them gun rights back. Otherwise, there's no path to doing so. So we're just talking about states' rights. So the states have the rights to do that. And if we don't do that, if we don't take away to give them back, then we just can't give them back. So because the federal government just doesn't have any way, or they're not abiding by restoration in any way.
Follow-up, please.
Representative Ottman.
Thank you, Mr. Chairman. Okay, can you briefly?
Point of order.
What?
Point of order being called. Representative Crago, state your point.
I just don't, are we still on the amendment or are we talking about the bill in general, Mr.
Representative
Chairman?
Crago, we are on the amendment, so let's tighten it up. We're on Committee of the Whole Amendment number 3. Discussion, Representative Ottman on Amendment 3.
Okay, so is this amendment to make, let me see, to adjust state law to federal law to make someone a criminal under a larger penalty to give them their rights back under a lesser penalty? And is that what this amendment would do?
Okay, Representative Chestnut.
Thank you, Mr. Chairman. No, it does not do that. This simply creates a situation where, so we have, the state is controlling whether or not you have your rights restored. And we are saying that if you commit another felony involving domestic violence, that shows that you are a risk. If you have a gun, you'd be more of a dangerous, situation. It doesn't create a new crime. It would be an existing crime of domestic violence. And whether it's a misdemeanor or not, if it's a felony, it would automatically disqualify you under the prior section. But the prior section has a loophole. If the domestic violence conviction is a misdemeanor, you still get your gun rights back. And that's the limited situation that this is intended to address. It's all under state law. As we use the federal definition of what domestic violence is. That's the only federal connection here. Everything else is under state law.
Further, question being called. I don't see anyone at the mic. Chairman Newsom, I'm sorry.
Oh,
Sorry, Chairman Newsom.
thank you, Mr. Chairman. So I'm maybe, along with others in the body, a little confused about the person being addressed in, on the amendment in line 6 through 12. So to the bringer of this amendment, is that person that we're referencing been convicted of a felony, and that's how they fall under this particular bill? And then if they have been convicted of a misdemeanor domestic violence, we're increasing the time in which they can get their firearm back from 5 years to 10 years. Am I understanding that correctly? Thank you.
Thank you. We're going back to Representative Chestnut.
Thank you, Mr. Chairman. And yes, the person referenced in line 6 is a person who has previously been convicted of a violent felony and thereby lost their right to carry a gun. And if subsequent to that, they commit an additional misdemeanor felony involving domestic relations, that means they have another 10 years to wait before they're allowed to apply for the restoration of their gun rights.
Further discussion. See no one at the mic. The question being called on Committee of the Whole Amendment number 3. All those in favor, please say aye. All those opposed, please say no. No. That amendment has failed. Question being called on the bill. Oh, we have a discussion on the bill. Representative Pendergraft.
Thank you, Mr. Chairman. This bill is a very personal thing to me. No, I've never been committed of a felony, but I have a couple of people very close to me that have committed felonies that have a particular interest in this. And so that acutely, I want to support this bill. I want to support what it would like to do, but I believe this bill has a fateful flaw in it. Essentially, the thinking in the beginning was that if we're going to restore someone's right, the right to bear a firearm, we can't restore something we haven't taken away. Right now, if someone has their rights taken away under a felony, that is through federal law. And so the thinking is, if we put it in state law, because we imposed it, then we have the right to remove it. And there are a number of people who have made pretty convincing arguments to that point. There are, however, a number of people, a number of good attorneys, who believe there are other ways to accomplish this, and they have not yet been fully explored. And I guess my message in short, now I do have a few more things to say about this, is that this bill is just not ready. There is a way to do what needs to be done here, I am firmly convinced, without writing into state statute our requirement to take away someone's right to keep and bear arms. I think anytime we start messing with those few God-given rights, we need to be extremely careful. We need to make sure that we get it right. We need to make sure that we have examined it very closely. This is a very complex bill, and it deals with the intersection of federal laws and state laws, and very hard to get a grasp. I spent several days going over the testimony, listening to it, and really trying to understand exactly what's happening. As the bringer of the bill, the sponsor of the bill, was speaking to committee, there were a number of questions that this sponsor was just flat unable to answer. And I think those questions need to be answered. One of them in particular had to do with maybe reciprocity, or maybe that's not the best way to describe it, had to do with how other states are going to react. Once Wyoming restores someone's firearm rights, can they cross a state line without fear? Are they protected? And the answer was, I don't know. Well, I think we need to find out those answers. I believe that there are answers. I believe that there are some very talented people out there that can help us to get there. But at this late hour on this day, I doubt there's anybody in here who's going to be able to catch all of the different things, parts that are in play, and understand all of the repercussions, all of the unintended consequences, and get it right. This is a very important concept. We need to do it right. We need to do it right one time. And I just don't believe that this is the time. So no on the bill.
Representative Provenza.
Thank you, Mr. Chairman. To the point of there must be some other way to do this, I will say we spent a lot of time in 2021 looking at the other way to do this. So there is one other way to do it, and it's expungement. And this body passed that. So expungement meaning we just erase your criminal history. It's not there anymore. We seal it. And that's for nonviolent felonies. And that, I think the time frame on that is 10 years. So there's that path, but folks weren't too keen on that because we're suppressing your criminal record. And where this says, we're not getting rid of it, we still have that record, but this allows you to have your rights restored. We already have a process that that goes through this. Several years ago, maybe it was the 2017 legislature, we restored rights for nonviolent offenses for certain folks, and that was something that Department of Corrections went through. So this isn't brand new. This is a conversation we've been having for a long time, 6 years. And this is the way to get through it, at least for the nonviolent felonies. So is it complicated? Yes. Unfortunately, it's complicated. It would be a whole lot easier to say, you know what, everybody gets their rights back. But that's not the reality that we live in. So we have to deal with bills that are a little bit more complicated, but do a good job of getting the goal of restoring rights, bringing people back into society, putting them back on juries, making sure they can vote. And that was something that I heard on campaign trail. And then over the summer, there were several arrests of people who went and voted. Not because they were trying to commit voter fraud, but because they thought that they no longer had that felony record. There was one gentleman I spoke to, he had a nonviolent felony of possession of cannabis. And this was, I don't know how many years ago. He thought that his sentence had been deferred because he hadn't been in trouble in 10 years. And he went and registered to vote. They let him register. And then he went and voted. And then he went to jail. Is that what you want? Because that's what's happening. We need to fix that. We want people to have their rights back. They've done their time. They've done all the work that needs to be done. And they have demonstrated that they're on a path to success. This bill does that. So, aye on the bill. Thank you.
Representative Ward.
Thank you, Mr. Chairman. As the good representative from District 9 or 29 alluded to, the bill slips in a penalty removing gun rights from nonviolent felons. I think that we can all support what the title of the bill says to do, but I think it needs some more work. We all support the idea of people getting their rights back, but the problem of slipping in a new penalty, removing gun rights from nonviolent felons is a real one. For that reason, I vote no. I urge a no vote on this bill. Thank you.
Representative Craigle.
Thank you, Mr. Chairman. I just want to point out that there is no new crime committed or created with this bill. Committed. There might be a crime being committed around here, but that's not it. If you look at on page 2, 68102, it still only applies to violent felonies or a felony under 65204, which is assault of a police officer. And so it does not create a new crime. There is no penalty for violating that provision for non-violent felons, and that was specifically left out. It's a discussion we had in committee, but we didn't go there. And we didn't want to go there, and that's why is we did not want to create a new crime where you would then be prevented from getting your gun rights back because you just violated the crime you violated the provision we're just trying to protect you from. And so there is no new penalty, but there is a removal of those rights so that they can be granted back by state statute. The federal law already removes them. The problem is the federal government is not restoring them. There's a budget footnote that prevents the government from doing that. And so if we're going to do it, we have to do it at the state level. And that's what this bill does. It helps those friends of ours who've done their time, who've paid their time, I should say, and allows them to get their gun rights back. And in order to do that, we have to, in words, we have to take them away. But we're not penalizing them. There's no new penalty. There's no new crime.
Chairman Washington.
Thank you, Mr. Chairman. I just want to reiterate this. When you're convicted of a nonviolent felony presently, you lose your gun rights under federal law. Okay? So if you're convicted of any of these nonviolent felonies, from that day forward, you've lost your gun rights. There is a mechanism to restore your gun rights if it's done through the state, but in order for that to work, the state must first take away your gun rights. We've never done that under state law. That's what this bill does. We have to take away your gun rights in order for them to be restored. A complicated process, but it works. And so I just encourage your support of this bill.
Representative Hornak.
Thank you, Mr. Chairman. I've got a question for, in section 2, this authorizes the Department of Corrections to hire one at-will employee, and then there's an appropriation for that. The at-will employee should deal with certification of restoration of rights. On a different topic, the Department of Corrections testified in a committee that it would take a lot of time and a lot of effort, and I'm just curious if the Department of Corrections, what their response to this was, and if they think that that one person can handle it, or if that was insufficient. The testimony that I heard in committee was that it would take numerous people many years in order to do something. But it wasn't quite as much as we're doing here, but you know, this does kind of create some retroactive work in the Department of Corrections. So I'm curious what was said by the Department of Corrections of how they are staffed and what they think, how they think they can handle this. Thank you.
Representative Pendergraft.
Thank you, Mr. Chairman. I'm a believer in fewer laws, better enforced. I would contend that many gun laws are not very well prosecuted, and that we have a lot of people out there who end up doing things and getting away with it that they should and oughta. A lot of us who are firm advocates of the Second Amendment believe that we need to be hard on crime. We need to sit down and say, hey, if you're going to abuse this God-given right, you're going to have to pay a price for it. We are responsible gun owners, we're responsible citizens, and we don't want somebody going around and messing it up for the rest of us. This particular bill, as I've stated before, though well-intentioned, is a very dangerous precedent, and then in adding or to knowingly possess any firearm into state statute, which has not been there before. Now, it has been contended here that that's the only way that we can turn around and restore somebody's gun rights is if we took them away. Well, anyone who's been convicted right now was not convicted by state statutes, they were convicted by federal statutes. And so that argument begins to lose a little bit of weight with me, although I admit I've not been to law school. I've been into one. I am told by a number of good people who are experts in this that there is another way, and all I'm asking is a little bit of patience. I wish that I could stand up here and explain that to you, but I got to tell you, it's complicated. It makes my head spin. But I have reason to believe that there's a way we can do this without dangerously adding this to our state statute that is unnecessary. And I would ask you to vote no on this bill, and let's come back and try to do this another way and do it better and do it more simply. Thank you.
Okay, seeing no further discussion, no one at the mic. Question having been called. All those in favor of Chairman Washet's motion that when the committee of the whole rise to support, do so with the recommendation that Senate File 120 do pass. All those in favor, please say aye. Aye. All those opposed, please say no. No. That Senate File 120 has passed Committee of the Whole. Next bill for our consideration is Senate File 133. Now, members, this might not be updated on your, is it? Okay, so Senate File 133, Chairman Northrup.
Senate File 133, sponsored by Senator Schuler. Student eligibility in interscholastic sports, an act relating to education. Mr. Speaker, your committee number 4, Education, to whom is referred Senate File 133 engrossed, student eligibility in interscholastic sports. Respectful report, same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Andrew, Berger, Clauston, Lawley, Northrup. Noes, Representatives Allred, Brown, Obermuller, Provenza. Representative Northrup, Chairman. This bill was referred to committee number 2, Appropriations. Mr. Speaker, your committee number 2, Appropriations, to whom is referred Senate File 133 engrossed, student eligibility in interscholastic sports. Respectful report, same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Larson, Nicholas, Stith, Walters. Noes, Representatives Henderson, Sherwood, Swanitzer. Representative Nicholas, Chairman.
Thank you. You've heard the reading of the bill. Now, before I call on the good chairman, thank you, reading clerk, because very well done. No pressure, the voice of the Wyoming House. Keep that voice going for a few more hours. But before I turn this over to the good chairman, I just want to remind the body, there is supper, pizza in the break room. Keep the quorum, but as you can move back and forth. So thank you for that. And now you've heard the reading of the bill. What's your pleasure, Chairman Northrop?
Thank you, Mr. Chairman. I move that when the committee of the whole rises report it do so with recommendation that Senate File 133 do pass. I also move the standing committee amendment and will have both of them explained by the good legislature from the Bighorn Basin.
From the heart of the Bighorn Basin, Representative Lawley.
Thank you, Mr. Chairman. Members of the House, I present to you Senate File 133, Student Eligibility in Interscholastic Sports, and ask for your favorable consideration. Now, to some of you who were here 2 years ago, this is a similar bill that was presented 2 years ago, but it was never debated in this body. And although I wasn't here 2 years ago, I heard a lot about it on the campaign trail, the fact that it wasn't debated by this body. So I'm thankful that we're bringing it out on the floor and we can have this debate. It's an issue that has not gone away in the last 2 years. In fact, there's been an increase in trans athletes competing in women's sports in Wyoming since the time that this was filed 2 years ago. But I want to talk to you about three major concerns that this bill will address concerning biological females who want to compete in athletics and experience the benefits of fair competitions, which was enacted in Title IX of the Civil Rights Act over 50 years ago. And those three issues are fairness, equity, and safety. Now, for those of you who don't know or are not familiar with Title IX of the Civil Rights Act, it gave all biological females their own lane to be able to compete on a level playing field against other biological females. This bill requires that if an athlete is born male, they are banned from competing against biological females in Wyoming public schools. But I want to be clear about what this bill doesn't ban, because I think that's really important to know. What this bill does not ban is trans athletes from participating in other areas like co-ed or club sports. This bill also does not limit districts from creating other transgender sports opportunities. In fact, it gives them the ability to do so. The bill simply bans biological males and trans athletes from competing in biological female sports only. And this, again, as I said, begins as a fairness issue. Regardless of whether a male has completely transitioned or is using hormones to begin a transition, they are physically superior to females in many ways. They are many times taller, stronger, and have larger hearts and lungs. Their muscular makeup and their bone structure is different, and so fairness in sports is destroyed if they are allowed to compete in the female lane only. There are many studies that show that females just simply cannot make up the difference. Biology does not go away even with hormonal treatments. The playing field is not level, and that's why we need this bill. Equity is another thing I mentioned. Equity also goes out the window. Females will have challenges in competition with biological males, and as a result, they're going to lose valuable opportunities and are losing valuable opportunities. We heard evidence of in our hearing where girls have lost valuable opportunities to continue on to compete in higher levels of competition. We had a mother who talked about her daughter who was eliminated from podium in a couple of different activities in track because of a trans athlete took her spot in that position. Finally, I want to talk about safety. This isn't talked about very much. Maybe it's simply implied, or maybe we understand to some degree inherently there might be some safety issues. But it is inherently unsafe for biological females to compete against, in most team sports, against males after they have gone through puberty. So there are safety concerns as well, and this bill addresses all three of those. We have already seen, as I alluded to earlier, female athletes in Wyoming who have lost opportunities to be on the podium while their places go to transgender athletes. I think we need to think long and hard about the emotional, mental well-being of female athletes when they lose out on these opportunities for success, for setting records, and potentially for scholarship opportunities. But I want to say this also. I'm not going to pretend that there are no potentially negative effects on transgender athletes and their well-being. I'm not going to pretend that. But I am saying that there are other options available to address those issues that don't require the dismantling of women-only sports and all the progress women have gained over the past 50 years in Title IX. That is really why the bill is needed. So, looking at the bill, what I want to do is give you a general outline of the bill, and then we'll turn to, and I'll move then at the appropriate time, the standing committee amendment, because we did make some amendments. But basically, the bill is a ban with a contingency, or what's called a fallback. So again, the general structure of the bill is a ban, as I mentioned earlier, and then a fallback provision, which we will talk about why it's important that's a fallback provision and what that means in a moment. If you have the bill in front of you, you'll see on page 2 definitions. On page 3 is where you'll see the wording of the ban. On page 5 of the bill, you're going to see more definitions. And then on page 6 is where we come to section 21-25-202. And this is what's called the fallback provision, or some would call it a contingency provision. And what that means is from this point forward, page 6 forward in the bill, is only effective if a court invalidates or enjoins the ban. So it's not immediately effective from page 6 on down. It becomes effective if a court enjoins or invalidates the ban. And what happens if that happens? If a court were to invalidate or enjoin the ban, the Attorney General would notify the governor that that has happened. And at that point, 21, 25, 22 is triggered. And then all the things in that provision begin to happen. And we'll go through that briefly, what that is. The first thing that will happen is the Wyoming Activities Association will appoint an independent school activity eligibility commission. And page 7 lays out the makeup of that commission. It's intended again to be apolitical. It's intended to be independent of different districts and what might benefit one district over another in terms of decision making. And then the commission, again, will be appointed, as I said earlier, by the High School Activities Association. And then pages 8 and 9 lay out the commission duties. Basically, what they'll do is promulgate rules to determine eligibility. The commission will look at safety risk and what types of competitive advantage the trans athlete would have when considering the outcome. And the decision and the proceedings will be confidential. So with that general description of the bill, I'd like to turn to Standing Committee number 1 and talk about that for a moment and work through that. So what we've done with Standing Committee number 1, Amendment number 1, and if you have it in front of you, the first few lines are really kind of conforming changes to things I'm going to describe to you in terms of conforming the title and some other things. The first thing you're going to see is that the Standing Committee amended what was previously a K through 12 public school ban and changed it to high school ban. And so that's where you see that word high school being inserted and some language taken out. And then again, conforming amendments. The next primary amendment from in the Standing Committee is actually on Standing Committee Amendment page 1 at the bottom, which begins on page 4, line 9 through 14. And the original bill is deleted. Some of that language is then included later. But you will see the amendment beginning at the bottom of page 1 that says, nothing in this section shall be construed to, and then there's a couple of things. And this is where these two things, Romanet 1 and Romanet 2, the purpose of these is to say that the ban does not restrict schools from doing certain things that I mentioned earlier, like number 1 is to restrict eligibility for any student to participate in any interscholastic activity, athletic activity designed for students of the male sex or designed as co-ed experiences. So we're just reiterating that we're not banning that. Districts don't have to do that, but they can do that. We're not mandating they do that. We're just saying, making it clear to districts, the ban was never intended to prohibit that. And the same with Romanet 2, has to do with permitting them to train and practice together, but not get spots for competition. So those are things to just say, districts could do that under the ban. Then going down to small e, there's some provisions that the Standing Committee puts in that are protection provisions. There's you see a shall not retaliate provision. So this provision is to protect when a girl or her family feels like they want to make a claim concerning another athlete's participation, and is it whether or not it complies with the ban, that they will not be retaliated against. And then you see that schools shall not be retaliated against also. That's actually the first one that's not retaliated against. Sorry, I got out of order there. But that for maintaining these separate sports, that they shall not be. And then again, students or their parents. And then F is about giving what I would call an administrative remedy under the ban, that if a biological girl is in a district that is not following the ban, they have an administrative appeal to point out that that district is not following the ban according to law. So that's an administrative appeal, and that's in Romanet F, right to seek review. And then if you look down in the amendment, we added a few more definitions of gender identity, the definition of high school, since the amendment was adopted by the committee to go to to make it not K through 12, but just high school. So we defined what high school was. And then again, some what I will call deleting some changes and conforming amendments. I'm on page 3 of the Standing Committee amendment. And then we get back to the fallback and some amendments made to the fallback provision. Remember, so what we just talked about are amendments to the ban and some things under the ban to point out what is not banned and some protections. And then we get to the fallback, and there was some concern by many that was expressed about the way that had been structured across the hall, and we felt that we could maybe improve on that. And so what we did here is that we determined, and we had testimony from the Wyoming High School Athletic Activities Association, and their willingness to do this and to work with us, but they would be the entity that would appoint the commission. Across the hall, the original bill that came to us had the governor doing that. Excuse me, the chief executive doing that.
I know we're.
Oh, it's in the
getting into-
bill. I guess it's in the bill.
Hold on.
Yep.
Yeah, just be careful. We're doing great. Keep on going.
All right.
All right.
Well, the chief executive, but so we have changed that and eliminated that and had the High School Activities Association create the commission, again, which is defined who's on that, what type of categories of people are on the commission, and then to be the ones to kind of manage that process. So that's the major change, one major change in the fallback. Another change that was requested was that the immunity clause that you see on page 3 at line 35, that gives immunity to the high school, the association, and to this commission that is created under the fallback provision. At the very end of page 3, the very last line 45 is about vouchers. There was already a provision in the bill that allowed the commission to at its discretion help maybe pay for some of the expenses that might be needed in this process, whether it was just to go through the process, whether it would be types of testing that might be needed or the commission felt would help them make their decision, that could be reimbursed. So that's part of what's there. And it was a may, the commission may do this. And so the amendment from the standing committee was that should be a shall, and that was added. So I'm on page 4 of the standing committee amendment now. And what we did here is that there was an amount in the original bill for $30,000 in order to pay the expenses of the commission, including some of these expenses that would relate with some of those that might be involved in the process. And the committee amended that from $30,000 up to $100,000. So that's what you see there on page 4, lines 4 and 5. And then there was the standing committee amended it to add a provision you see there on page 4, lines 9 through 25, putting in an appropriation for $1 million from the general fund for the governor for purposes of funding litigation. So that is the standing committee amendment. I move the amendment at this point.
Now, the amendment was moved by the good chairman right at the beginning with the bill. So it's been moved. Now, the question being on the standing committee amendment, we're on discussion now, standing committee amendment. Representative Stivar.
Thank you, Mr. Chairman. On and against this amendment. This is fairly simple, ladies and gentlemen. Look at their birth certificates. That's all we got to do. On and against.
Okay, any further debate on that standing committee amendment? Representative Heiner.
Thank you, Mr. Chairman. Question for the good bringer. This amendment narrows it down to only those within the 10th through the 12th grade or high school. And puberty happens before the 9th grade, where we know that some of this muscle structure begins to develop. So I was wondering why it was limited to 9th grade and not also in the junior high, so 7th grade through 12th grade.
Okay, Representative Lawley.
Thank you, Mr. Chairman. Thank you for that question. There was quite a bit of, there's some discussion about that in the committee, and one of the reasons would be because the Wyoming High School Athletic Association really only has, jurisdiction over high school, but the feeling that, I guess I could just say that's just what the committee adopted.
Remember, that the name of that association is being said, but they are in the bill.
They are,
That's why we're
yes.
going with that at this
Absolutely,
point.
they're in the bill.
Any further discussion on the standing committee amendment number 1?
Question.
Seeing none, question being called on standing committee number 1. All those in favor, please say aye. Aye. Those opposed, please say no. No. That amendment has been adopted. We are now on standing committee amendment number 2. I need an appropriator. Good Chairman Nicholas, standing committee amendment number 2, please move and explain.
Thank you, Mr. Chairman. I would move standing committee number 2 to Senate File 133 and ask for your favorable consideration, ladies and gentlemen. So what we did, if you go to the back of the bill, there's an appropriation of $1 million, essentially to fund any litigation expenses that may happen as a result of passage of this bill. So we had testimony in the Appropriations Committee from a trial lawyer and also from practical experience on some of us on that committee, that there's a likelihood that this bill may conflict under Title IX because it creates a discriminatory class, theoretically. What the testimony was in our committee is that if that happens, number one, typically they award attorney's fees, and they also award damages. And in other places where similar issues have arisen, frankly, $1 million won't be enough. And so we said, why just peg a number at $1 million on what those damages are when we don't know what they are, we don't know when it's going to happen. We do know that I don't think there's any question that this bill will be litigated, that the Attorney General's office will represent the state of Wyoming and in our actions. But whatever those damages are, we'll know it when we know it. And so to us, it just made more sense to take this appropriation out with the understanding that we may very well be responsible for $1 million plus or $2 million or $3 million in attorney's fees and costs in this in potential litigation. So that's why there's no reason to stick $1 million in now. So we removed it, and we'll cross that bridge when we get to it. So on support of the amendment. Thank you.
Okay, any further discussion? We're on number 2. I just want to be clear. I want to ask the chairman of appropriations, does this amendment then take it down to 1 appropriation in the bill? Okay, thank you. Just so we're all, okay, Representative Sherwood.
Thank you, Mr. Speaker. As somebody who voted no on this amendment, I just wanted to share with the body a different perspective, because that's how we get healthy debates, is looking at an issue from different perspectives. So we did hear in testimony that this may cost us up to $2.5 million, that some of this money may in fact come out of our school district's budgets. And then if this goes to the Supreme Court, it may cost us up to $20 million. So I just wanted to share that perspective from public testimony with the body to say, whether we put an appropriation in this bill today or we let the Attorney General deal with it, it is going to cost us taxpayer dollars to fight about the constitutionality. Thank you.
Okay, any further discussion on Standing Committee Amendment number 2? Seeing none, all those in favor, please say aye. Aye. All those opposed, please say no. That Standing Committee Amendment number 2 has been adopted. We're now back on the bill, and we're at the point of work of Committee of the Whole Amendment number 1. I would recognize Representative Larson Lloyd.
Thank you, Mr. Chairman. I'd like to move Committee of the Whole Amendment number 1 and to Senate File 133 and consider for your adoption. In the Standing Committee Amendment, they put in a new in which reads, any person who serves on the commission or on the Wyoming High School Activities Association is immune from any liability arising from complying with or administrating the act. Then it says this immunity shall apply to any healthcare provider. We're in an area there, and my question was, what's a healthcare provider? It's not defined, and so in my amendment, I would put after healthcare provider as defined in 3531-101A, Romanant 3, and if you would go to that, what it says is a healthcare, and that's in the voluntary healthcare section of in section 35, and it says healthcare provider means any person licensed, certified, or otherwise authorized by law of this state to diagnose, cure, treat, prevent impairments of the normal state of the mind and body, including but not limited to physicians, physician's assistants, nurses, pharmacists, optometrists, dentists, psychiatrists, psychologists, and social workers. I just think it's important as we get into some of this, particularly when we're granting immunity in areas, to have a clear understanding of what who we're referring to and by definition. So that's why I put that in to clarify. So ask for your adoption.
Okay, discussion, Representative Lawley.
Thank you, Mr. Speaker. I view that as a friendly amendment, and I think it does help to have that defined. Thank you.
Further discussion? Question being called. We're on Committee of the Whole Amendment number 1 to Senate File 133. All those in favor, please say aye. Aye. All those opposed, please say no. That amendment has been adopted. We're now on Committee of the Whole Amendment number 2. Representative Klaus.
Thank you, Mr. Chair. I move Committee of the Whole Amendment number 2 to Senate File 133. So the idea of this amendment is to take politics out of the decision. So we would remove, what would happen now is if someone is not happy with the decision of the high school association, they have the right to appeal that. So instead of having appeal it to the state superintendent and having politics in this, we're going to name the state board to take a look at it. And we actually have an office that hears cases here in Wyoming, and their purpose is to conduct fair and impartial contested case hearings statewide in disputes between Wyoming residents or guests and state government agencies. This agency is uniquely situated to act as an independent and partial hearing authority because it is a separate operating agency with no agency interest in the substantive issues presented in any cases it hears. The parties are therefore assured of a neutral process that will favor neither side. So this group will hear the appeal case then and make a recommendation to the state board. The nice thing about this is a very small, limited group instead of someone having to appeal their case in front of 14 people. So on this, I'm going to ask for your favorable consideration to try to take politics out of this and make it a little bit more impartial. Thank you.
Representative Lally.
Thank you, Mr. Chairman. I consider this also a friendly amendment, but I want to make sure the body knows what we were talking about here. This is, again, above the fallback. It is not regarding anything about the fallback process. So if you look to your standing committee amendment that we just passed a little bit ago on page 2, and line 32 and 33, currently provide this. Remember, this was where we added an administrative right to appeal for a biological female whose district they feel is not following the ban. And they have some way to point that out through an administrative process, more than just a megaphone, but an actual process to file. So that's what this relates to, and it currently has in its state superintendent of public instruction. And so what this amendment is doing is, instead of the state superintendent of public instruction, it is putting in the state school board under using a committee, a group they already have to handle appeals. So that will be the administrative process. And again, I appreciate the good representative for bringing this, because it does take it out of that political position realm and has it handled there, that administrative appeal. So again, I encourage your aye vote on that amendment.
Discussion on committee of the whole 2. Question being called. All those in favor of committee of the whole amendment number 2, please say aye. Aye. Those opposed, please say no. Okay, that amendment has been adopted. We're back on the bill. Division being called on committee of the whole amendment number 2. All those in favor, please stand. Just want to make sure in the back, leaning looks like standing. Okay, thank you. Okay, hold real still. We're going to do that again. This is everybody in favor. Please stand. Again, this is on committee of the whole amendment number 2. Okay, all those opposed, please stand. Nobody move. Okay, we're going to count a second time. Okay, that committee of the whole amendment number 2 has been adopted, 31-29. Okay, we're back on the bill. Further discussion. Representative Yin.
Thank you, Mr. Chairman. So I have several questions, but I think the first one is, how many people is this bill going to affect? How many kids are we talking about here? Especially when we're talking about maybe making a new lane for them. How many kids do you need to make a sports league, and is it less than double digits. And so I do worry about whether that's an appropriate fix for those kids. And then with regards to safety concerns, on page 2 of the amendment, so it's talking about it won't restrict eligibility for a student to participate in sports for the male sex or co-ed or mixed. So if you have a school district that only has male sports, are we saying that both trans males and trans females are supposed to compete in that? And are there safety concerns with allowing that, if we're saying that there are safety concerns with allowing trans females to compete in female interscholastic sports? So I do wonder if that is almost more dangerous for either allowing a trans female or trans male to be in the locker rooms with just males. And so I think that's a question that I would like to hear from the co-sponsor. And then, yeah, I mean, I think the biggest one is just how many kids are we setting up a commission to affect? Thank you.
Representative Haroldson.
Thank you, Mr. Speaker. So the thing that I was going to actually have, my daughter wanted to testify on this bill because tomorrow night she goes into her track, her first meeting with coaches for track, and she told me, she said, "Dad," she goes, "I don't want to have to compete against a guy." She goes, I can't compete against a guy." She runs 100, she runs 200, and she does pole vaulting. So you ask, who does this affect? I'm going to tell you right now, it affects every girl in this state. Every girl. Every girl that has to go out there and have their record taken off of a wall. Every girl that goes out there and can no longer compete in the sport that they're training for. Every girl that cannot get the scholarship they were going after because they did not compete because of that issue. I mean, we're seeing this across the country. So who does it affect? It affects every single person. Is it a complicated discussion? In ways it is. I'm not discounting that or disagreeing, but we're at a point right now where we have to ask the question, is it fair for my 15-year-old daughter to have to go out with a pole vault in a category where an 11-foot pole vault is really tall for a girl? An 11-foot pole vault is not really tall for a boy. And we have to start asking some questions, you guys. And so I challenge you as we think about this, as we go through the amendment process, as we do all of this, at the end of the day, who do we need to protect and what are we called to protect? We're called to protect those girls, the girls that are out there busting their rear, working hard, doing what they need to do to be able to be the top of their game. And the reality is, if we're not careful, they're not going to be able to do that. So that's who we affect here.
Representative Obermiller.
Thank you, Mr. Chairman. Well, the vote in this committee was 5-4, so there's obviously another way of looking at it. And I'll hope you'll listen to the other side of that argument. The only real question here, as you've listened to the debate, is the question of fairness, right? And fairness is a concern that is dealt with all the time in sporting activities, and this should be no exception on a case-by-case basis. And we have processes to handle rule violations, rules written by school boards and a sports association. In addition, we have an appeals process through the association to handle fairness issues. In the case of trans athletes, to date, there have been no appeals. That's correct. In the case of trans athletes, there have been no appeals on either side of the issue, according to the association that adjudicates fairness matters. So what does this bill do? Does it wait for the appeals process to play out? Nope. This bill is a broad brush against an entire class of citizen, banning a group. In the long run, we preserve our own freedoms only through the hard work of protecting the rights of others, while at the same time working through the difficult and nuanced issues of sports fairness, one child at a time. It's not easy, but it's the only fair way to do it. It's ironic that a bill about fairness is on its face unfair in its targeting of a particular group of Wyoming kids and completely ignoring all the other ways unfairness is acted out in the arena of sports. So I will be a no vote today. It's a lonely road, but certainly not as lonely as one traveled by the kids that are being targeted as they follow these proceedings and seek protection of their rights to process and to be seen as individuals just like everyone else. That is the Wyoming way. Thank you.
Representative Lawley. Had some questions there. I'm just going around the room.
Thank you, Mr. Chairman. How many kids are affected? Again, it's really unknowable. I will say this, in the dynamic we had during the committee with testimony, which was helpful, and I was glad everyone was there for that time and they had a chance to speak. But something struck me that evening in our committee, and that was while we heard a lot of testimony about the dynamic and the difficulty and the challenges of being a trans kid in a Wyoming school, and that was very touching, and I think it's really some unique things to consider. Not one said that they wanted to play sports. So I don't know how many. All I know is there are kids playing and it's disrupting the lane for females only. That's all I really know standing here today. I don't know what opportunities districts can provide, but we are giving them we're doing nothing to affect their authority to do that and to try to come up creatively with ideas to do that. And that's where that belongs, I think, is for them to decide as districts. So we can't know. We know a lot more about the dynamic with the females because we know about the lost opportunities, and we heard testimony about that, and even the original sponsor of the bill, her own experiences she talked about in committee as a coach. And so, you know, I don't know, but where it is impacting, it's impacting significantly in terms of females. And again, I go back to what Title IX created was a lane. And that lane is based on objective facts about biological male and female sex. One of the reasons the courts have struggled with this, and we don't really have an answer from them, is because the idea of gender identity, and you see it more clearly as you move to gender fluidity, is more subjective. And so you've got laws that are conceptualized in ways that are objective, and then we have some things happening in the subjective realm. So it is a hard situation. But again, I will emphasize that the blowing up of Title IX, the lane created for biological women to solve the other issues that I think are real. I really do. I want to give that due credit. And I actually would stand against anything that diminishes that. But this isn't the answer to that. This is not the answer. I don't have what all the answers would be, but the districts, I want them to know they have leeway to come up with some good ways to address it, and I hope they do. So we were also asked about the issue on page concerning the, I think you were referring to the amendment Romanet 1 underneath the ban, where it talks about it doesn't restrict the eligibility for students to participate in interscholastic athletic activity designated for students of the male sex or designated as co-ed. And I think the question was, if I understood it from the good bringer, the question was that, is this saying that trans females can play in male sports? That is not the intent of that, but I guess you could interpret it that way. But again, this is just saying districts are not restricted from doing certain things. I guess I mean, I'm not sure, but it's possible, I guess, that a district could decide to do that, although I'm not sure they would. So again, that's not the intent of that provision. It's actually just trying to say, look, the district has some leeway here that the ban does not restrict. And so I hope that answered that question. I want to go to the question that was brought about it's not really needed. The Wyoming High School Athletic Association can do this. They haven't had any appeals. Well, while it's true that they have not had any appeals of various district decisions, I don't think we can speculate as to why they haven't had appeals. But I will tell you this, that even the testimony we had from the Wyoming High School Activities Association, and even my own review of what regulations they currently have concerning eligibility, basically they are not set up to do this. That's why we have the commission. So anyway, I think that's it.
Okay, Representative Trio.
Thank you, Mr. Chair. I'm for this bill. I have 4 granddaughters, 2 daughters, 2 stepdaughters, and I just find it appalling that we are not protecting women. Granted, I feel sorry for people that have gender dysphoria, but there are lanes, and women are women, and we need to protect women. Even watching my granddaughters play in co-ed sports, you can already see the difference in late elementary to early junior high, the difference between male and female, whether they're on hormonal medication or not. So I really need all you men to pay attention and protect women. Thank you.
Representative Ward.
Thank you, Mr. Chairman. As a mom of 11th and 12th grade girls who compete in track and field and golf, one of whom made it to the state championships in golf and is poised to get a scholarship, I am in support of this bill. I'm not alone. There are famous feminists, one in particular, a famous tennis player, who also believe that women's sports should be protected. This bill isn't perfect. There are some provisions I would like to change, but it's a start. I would like to also point out the entire point of Title IX is that biological girls would be able to compete in their own sports as girls. It is not fair to make a girl compete against a biological boy. In support of this bill.
Representative Sherwood.
Thank you, Mr. Chairman. I would say competition is a good thing and that it brings out the best in us and it stretches us. And without diminishing the very tall qualities of our minority floor leader, I would point out that sometimes there are height differences that play into account. If you would take our good minority floor leader and stack him next to our minority whip and bet on who may win a pole vaulting competition, I would always bet on height, not gender, just saying. But in all seriousness, I do want to just take a moment to thank the House Education Committee for the good work that they did in watching that meeting. And if you haven't had a chance, I would encourage you to go back and watch that meeting. It was civil, it was respectful. The individuals who wanted to testify were given the time to do so, and they were heard. Even though I don't agree with the bill, I want to celebrate the process that it went through and would hope that all of our committees would give that same level of civility to all the bills that we see. So I just felt like that needed to be said. But I do have other questions, and thank you for your patience in addressing them. So during the testimony, did anyone come forward as a student, as a high school student, who felt that their rights to play were being impaired by a trans athlete? I think that's a perspective or voice I'd like to hear from. And then on page 6 of the bill, there is a legal contingency. So for those of us in the room who might feel that the bill is constitutional, I would say, then why do we need that section? And for those of us in the room who may feel the bill is not constitutional, why not just leave the current process in place that focuses on local control through the Wyoming High School Athletic Association that did, during the House Education Committee meeting, walk through their adopted written process for appeals? So I would say, I don't think a commission is needed. I think that this can happen, these conversations at the local level where we know the parents, where we know the kids, where you have that level of sort of intimacy of community. And that's really, to me, where this conversation should happen. And so again, legal contingency in the bill. So maybe we're preparing for that lawsuit. But it also begs the question of what equality state problem are we trying to solve with this piece of legislation? Thank you.
Representative Slagle.
Thank you, Mr. Chairman. On and for this bill, I don't agree with it the way it's now amended, but it's better than nothing. What I think is legislators, we're not looking at this truthfully. There are biological males and biological females. And that's what Title IX was come up for, is so that biological females didn't have to compete with biological males. And I think we have this issue, and we're beginning to gray that line. And there is no gray line. There's one and there's the other. There are people that feel they belong in a different gender, and I understand that. There are also people that think they should be animals. But just because we think we should be something doesn't mean we are. On and for this bill. Thank you.
That was a question called, but I think Representative Ottman wants to add something. Go ahead, Representative Ottman.
Thank you, Mr. Chairman. I would just like to say, if states do not uphold Title IX, they'll lose certain federal funds. Title IX was created to protect our females in school sports. So if Wyoming doesn't ensure equal access in sports for females, we risk losing precious federal funds. If we let boys compete with the girls, I'm sorry, I wrote in pencil. This clearly eliminates equal access to sports for girls. Boys always have a place to compete on the boys' team, just prohibited from competing against girls. Men and women are created with different strengths and abilities. And here in Wyoming, we have a lot of small districts. Anyway, think about Title IX. We don't want to mess that up. And I ask that you vote aye on the bill. Thank you.
Further discussion. Okay, Representative Hornock.
Thank you, Mr. Chairman. So just wanted to talk briefly about all we're trying to do here. I know this is kind of a growing political animal, but let's boil it down just a little bit. The question really is, what do we value in that balance that we're trying to figure out here? Do we value complete inclusion at the expense of biological females, or are we going to set boundaries and limits to ensure that women's sports and the girls that play in it are protected? We've got to draw the line, and in drawing a line, we will probably discriminate. It's just part of the process that this takes. There's a growing definition of what a male is and what a female is. All the time. We've seen that over the last several years. It's growing. And so that growth has kind of outgrown the britches of where we have defined male and female sports. And so all we're trying to do here is, in that growing definition of what a male and a female is, especially dealing with females in this particular bill, are we going to draw a wide line to include all of them, or are we going to draw a line where it's been for a long time in order to protect the sport itself and some females. How are we going to define that? So I'm just asking you to vote your conscience and don't sell the truth in this. Thank you.
Chairman Harshman, are you wanting to speak? No. Representative Provenza?
Thank you, Madam Chairwoman. You know, we heard that this bill is about safety. Yet I didn't hear a single case where physical safety has been reported. I didn't hear any allegations or any evidence to suggest that there has been any physical harm endured during interscholastic sporting activities. We heard that this bill was about fairness, but there's no consideration of the individual differences between people. As we mentioned, the pole vaulting or whatever other physical activity, there are many differences between people. There's no testing of anabolic steroids of males. There's no consideration as to whether size is a difference. We also heard that this bill is about Title IX and fairness to women, and that Title IX is all about women playing sports. Well, that's factually inaccurate. Title IX isn't about women. Title IX is about protecting students from discrimination based on sex. There's a difference. We heard the current process isn't working, but there hasn't been an appeal in 9 years. There hasn't been an appeal in 9 years. We heard that this was about protecting girls, but nothing protects or ensures that your daughters or your granddaughters won't be targeted as being trans. Anybody can report this. I can go say that your daughter is probably transitioning and she therefore shouldn't be able to play sports. And then she gets to go in front of the commission and justify that she is not under transition. When I was 12, my parents had to carry around my birth certificate when I played softball. I also played baseball because I was tall. And maybe it was that I was 16 and not 12. Maybe it wasn't that I was a girl. Article 1, Section 2 of the Wyoming Constitution, and I'll contend also our United States Constitution, says that equality of all, in their inherent right to life, liberty, and the pursuit of happiness, all members of the human race are equal. We are creating separate classes. There's a justice, I can't say his name, but he's known as the Great Dissenter. And he said, a very small minority of people having equal rights doesn't harm the majority, but infringing on their rights is an infringement on all of our rights. And that Great Dissenter also said, separate is not equal, that we couldn't separate people and provide them constitutional rights. He was the dissenting opinion in that particular case. Decades later, the court found that he was right. The Great Dissenter was cited as being correct when the highest court of the land found that separate is not equal. This is a constitutional violation. Right now, the process we have hasn't been challenged because we're dealing with it on an individual basis. The people closest to the problem are the people that are closest to the solutions, and they've been doing a good job. This and any bill that we pass that is flying in the face of our Constitution, our oath to this office, is deconstructing the rule of law. It's deconstructing the courts, the legitimacy of this country. It is deconstructing the legitimacy of your seat in this body. You vote for this bill, you are approving that message. No.
Question being called. All those in favor of Chairman Northrup's motion that when the committee of the whole rises to report, it do so with the recommendation that Senate File 133 do pass, say aye. Aye. Those opposed, no. No. Senate File 133 has passed the committee of the whole. The next bill or resolution for our consideration is Senate Joint Resolution 11. The reading clerk will read the resolution.
Senate Joint Resolution 11, sponsored by Senator Larson Dan. Convention of States, a joint resolution requesting Congress to call a convention for proposing amendments to the United States Constitution as specified. Mr. Speaker, your committee number 3, Revenue, to whom was referred Senate Joint Resolution 11, Convention of States, respectfully reports, same back to the House with the recommendation that it do pass. Ayes, Representatives Byron, Harshman, Northrup, Oakley, Zwanitzer. Noes, Representatives Bear, Locke, Storer, Strock. Representative Harshman, Chairman.
You have heard the reading of the resolution. What is your pleasure, Chairman Harshman?
Thank you, Madam Chairman. I move that when the Committee of the Whole rises to report, it do so with the recommendation that Senate Joint Resolution number 11 do pass. There are no amendments, and I turn the explanation of the joint resolution over to the good co-sponsor from the capital city.
So there is a committee, just for clarification, there is a committee of the whole, but nonetheless, Representative Singh, are you going to explain the bill? Please proceed.
Thank you, Madam Chairman. And thank you, ladies and gentlemen.
Point of order.
What's your point?
I'd like to call a Rules Committee on the constitutionality of single subject.
Are you referring to the amendment? Okay, so it's on the whole, okay. All right, Rules Committee to the front. Let's see. Okay, after the Rules Committee met on the objection, it is, I'm ruling, I guess, along with the finding of the Rules Committee that the point of order is out of line, is incorrect, that the single subject is not violated according to this, the way this is written, that indeed this is about a single subject of the Convention of States. It is not multiple amendments. Therefore, I overrule your objection, Representative Jennings, and ask if you want to withdraw or if you would like to appeal the ruling.
I'll withdraw, Madam Chair Lady.
Thank you, Representative Jennings. So, Representative Singh, if you'd like to continue.
Thank you, Madam Chairman. And thank you, ladies and gentlemen. I bring before you Senate Joint Resolution 11, and I ask for your favorable consideration. This is an opportunity to express our responsibilities as a state legislature as the founders intended. From the founding of our nation, we have always emphasized the necessary relationship between the federal government and the states. Unfortunately, we have seen the expansion of the federal government without a counter mechanism to properly challenge it. The founders knew that the federal government would require future instruction by the people and wrote Article 5 into the Constitution for that reason. It is the ultimate expression of federalism, the division and sharing of power between the national and state governments. We have heard from our members of Congress on how ineffective our federal system is at correcting itself. Our good representative pointed out at the beginning of this session that we are about to hit a fiscal brick wall. Attempts to put limits on Congress from the inside have been futile, as restricting one's own power while in power goes against their own interests. Our former representative has commented on how powerful a factor fear is in making legislative decisions that could potentially affect the powerful. Additionally, our good senator came to speak to this body to remind us that the states have a superior, more effective form of government than the federal system because of the intense bureaucratic rules that dictate their ability to discuss ideas. The Founding Fathers intentionally wrote Article 5 to empower the states if the federal government needs to be checked by the states. It was brought out of fear that the federal government would grow to be oppressive and unresponsive to the people. It was brought forward and proposed in its current form, where notes say it was unanimous, not even an ironic no. Senate Resolution 11 calls for an Article 5 Convention of States limited to proposing amendments to the Constitution of the United States that impose fiscal restraints on the federal government, limit the power and jurisdiction of the federal government, and limit the terms of office for federal officials and members of Congress. And so if you look at the bill itself, you'll see on page 1, so it describes that this is a joint resolution, and then it goes into all of the different reasons why we're going forward with this decision, so the different whereases. And then on page 2, starting on 16, you see the reason, the specifically what we're calling for in this convention. And so the section 1 says that the legislature of the state of Wyoming hereby applies to Congress under the provisions of Article 5 of the Constitution of the United States for the calling of a convention of the several states limited to proposing amendments to the Constitution of the United States that impose fiscal restraints on the federal government, limit the power and jurisdiction of the federal government, and limit the terms of office for federal officials and members of Congress. And then section 2 talks about what powers Congress has over this decision itself and the relationship that Congress has with this convention. Section 3 talks about this application, and then section 4 talks about instructions to the Secretary of State concerning this convention. So this application limits the topics of this convention to allow for multiple proposals that restrain federal power. Of course, any proposals would have to be ratified by 38 states. 38 states. The Convention of States application has already been passed by 19 states. Wyoming has voted in favor of a Convention of States resolution 7 times in the past. So there is already statute concerning what Wyoming would do in a Convention of States, and that is found in Wyoming Statutes 9, 22, 102. What would the rules look like? So the rules would work the same way that our House rules work. Initially, the state that first called for the convention, in this case Georgia, temporarily gets to name the chair and adopt the temp rules, and likely that would be Masons, as 75% of all state legislatures use that as their base. And then they would work on permanent rules, such as committees, after they elect a permanent chair of the convention. So some of the basic rules are paramount. Each state gets one vote, so it's one state, one vote, which is the most beneficial system for the state of Wyoming. Each state certifies that their delegates are bound by the decision of their respective state, and the convention is subject to the germaneness of the applications that were passed to call the convention. Anything proposed outside of why the 34 states agreed to meet could and would rule out of order. And additionally, how would our delegation be selected? And so according to Wyoming Statute 922-102G, the Secretary of State shall notify the President of the Wyoming Senate and the Speaker of the Wyoming House of Representatives in writing of the need to assign delegates or alternatives to the Article 5 convention. The members of the Senate shall elect 3 members of the Senate to serve as delegates, and the members of the House of Representatives shall elect 3 members of the House of Representatives to serve as delegates. If a delegate becomes unable or ineligible to serve, the President of the Senate or the Speaker of the House shall assign an alternate for the delegate who has become unable to serve. An alternate delegate assigned under this subsection shall immediately be entitled to represent Wyoming as a delegate in place of the delegate who is unable to serve. And so again, I see this as an opportunity to positively affect our country, and I stand for questions.
Representative Stivar.
Thank you, Madam Chairman. On and against. If you look at the Constitution, there's only a little paragraph under Article 5. There's no rules. We got to remember James Madison warned that those who secretly wish to get rid of our Constitution should push for a convention under the pretext of getting amendments. Think about that, guys. On and against.
Representative Banks.
Thank you, Madam Chairman. Got to be quick. I want to speak to, my name is on this bill, and that was a freshman mistake. I realized that after study. We don't have a problem with the Constitution. The Constitution, and the way it's interpreted, and people who follow it, or lack thereof, that's the problem. We need to just get back to where we follow the Constitution and where we interpret it the way it was intended, the way the Founding Fathers intended it to be. So on and against.
Representative Pendergraft.
Thank you, Madam Chair. On and against. We talked about countermeasures to counter federal overreach. There are a number of ideas out there, a number of different things that we can do simply within the framework of the Constitution. We need simply make that work, and we can do that. But I want to mention that once this convention begins, there's no going back. The very first thing that these delegates would do to that convention is to make rules. And yeah, we go into this with the idea that we have all these ideas about what it's going to be. And some of them are good ideas. I mean, a balanced budget is an excellent idea. It's mandated here in Wyoming. Term limits is debatable, but I understand the sentiment behind the pressure to do so. This is not the right countermeasure, though. As I said, once that convention begins, it's not going to be undone. It's not going to be stopped. There are no predetermined rules. We have concepts, but just like the very first thing that we did when we convened here as the 67th legislature, we adopted the rules. One rule that's been suggested is one state, one vote. How far do you think that rule would go in a popular vote among 50 states, including states on the far left coast, et cetera, et cetera? This is an extremely dangerous precedent. We can't go back from this. We haven't even tried seriously to fix those things that ail us within the framework of the Constitution. On and against, adamantly against.
Chairman Olson.
Thank you, Thank you, Madam Chairman. Excuse me. The hour is getting late, so I don't want to belabor this too much, but I do want to address some of the points that have been made so far. This idea that there are no rules, I want to push back against that. While there may not be inside of the resolution the basic procedure of the day-to-day, there are rules. In fact, that's what the resolution is a list of what the rules are. On page 2, section 1, very specifically, the rules are limited. States are limited to proposing amendments to the Constitution for 3 categories. Those are rules. Number 1, to impose fiscal restraints on the federal government. Number 2, to limit the power and jurisdiction of the federal government. And number 3, to limit the terms of office for federal officials. Those are the rules. Those are the rules that you have to play within. You can't propose amendments outside of that realm. How your day-to-day procedure works, are they going to use Robert's rules? Are they going to use Mason's? Yeah, those might be undetermined at the time, but I don't think those are that which procedure you use day-to-day is going to have a catastrophic effect on the nation. Number 2, the no going back. I want to address that because there's 2. The bill speaks to this very clearly. If you go to page 5, under section 2, the last Romanette there is probably the most powerful one, I think, in terms of recall. It specifically says the legislature, that's us. We have the power. We may, at any time, provide further instructions to the delegates. There's more rules that we, as a body, have control over. If we decide that our delegates are moving away from where we intended them to be, we can provide further instruction. And if they move too far away, the second part of that sentence says that we, the legislature, may recall the delegates at any time. So we can call them back and we can say, you're not doing the job right. And the last thing I will say in terms of rules is that it comes out of Article 5 itself. Article 5 is going to require that 34 states have to agree to call ourselves to a convention to have a conversation. But what's really important is that it's going to require 38 states to amend it. On and for the bill.
Representative Ward.
Thank you, Madam Chairwoman. On and against this joint resolution. Supporters of the resolution are under the misconception that a convention could be limited to specific issues. That is incorrect. One of our founding fathers, whose initials are JM, refused to call for a second convention to incorporate the Bill of Rights. He said absolutely not. It would be too risky to reconvene. He correctly perceived that another convention would open a can of worms. He insisted the Bill of Rights be added to the Constitution in appendix format. 1988, Chief Justice of the Supreme Court agreed when he said, "There's no way to effectively limit or muzzle the articles of a constitutional convention. The convention could make its own rules and set its own agenda. Congress might try to limit the convention to one amendment or one issue, but there is no way to assure the convention would obey. A constitutional convention would shake the very foundation of our representative republic. While conservative states would likely use a convention to try to reduce federal authority, liberal states would almost certainly use it to go after the Second Amendment and the Electoral College. A convention of the state should be avoided at all costs. If Wyoming legislators would like to change the Constitution, we could do it one amendment at a time." On and against.
Speaker Pro Tem Stith.
Madam Chairman, I think the representatives from Districts 12, 29, and 57 have it exactly right, on and against Senate Joint Resolution 11, for a couple of reasons. I think it's worth taking a look and reading slowly through Article 5 of the United States Constitution. The first thing that it says is that the Congress shall propose amendments to this Constitution on the application of the legislatures of 2/3 of the several states shall call a convention for proposing amendments. So once the legislature passes this resolution, Once we do this, our role is over. We've made the application. It's up to Congress then to call a convention. And there's nothing in Article 5 of the US Constitution that says Wyoming delegates have to attend. It just says a convention. We can go there and pound our fists and beat our shoe on the table and say we don't like what's going on. And if our delegates misbehave, we can recall them, but that doesn't stop the convention. Once we pull the trigger and apply for it, and if 3/4 of the states do, or 2/3 of the states do, then it's done. And then now you've got a convention, and there truly is no rule to control it. The only thing that a convention cannot do, there's only two things in the US Constitution that a convention of states cannot do. And they're listed right in Article 5 of the US Constitution. And those two things are, you can't ban the importation of slaves before the year 1808. Okay, you can't do that. And the other thing you can't do is to deprive any state of its equal suffrage in the Senate. So the only thing this convention, if called, cannot do is take away our two senators. After that, it doesn't matter what kooky rules we make up. We can make up all the rules we want to about how our delegates are supposed to behave, but it won't matter. So this is very dangerous. I love our Constitution. I love my Second Amendment rights. I don't want to see them dealt away at a convention of the states. The right not to testify against myself, that's important. The right not to have unreasonable search and seizures, that's important. The right to counsel. All of these rights that we cherish in our Constitution, all of them are at risk once you call a convention of states. So on and against.
Representative Pendergraft.
Thank you, Madam Chair. I want to talk about rules and our compliance to them. We talk about we're going to have rules for this convention, and of course, everyone would follow those rules. I would suggest to you that that's false, and I'll use this very chamber this very day as an example of that. We are governed by the Constitution of the state of Wyoming. And in this very chamber today, we heard two impassioned appeals to apply our laws to the Constitution of the state of Wyoming. I delivered one, and the good representative from the 45th delivered the other. And we were both completely ignored immediately. Folks, we have way, way too much to risk. If you value the Bill of Rights, if you value your Second Amendments, go ahead and vote for this. On and against.
Representative Penn.
Thank you, Madam Chairwoman. So on page 2 of this bill, line 2, it says, whereas the federal government has ceased to operate under a proper interpretation of the Constitution. So why is that the case? Have we allowed a situation where the Constitution isn't being interpreted properly, isn't being followed? The Constitution doesn't allow for this government overreach. The Constitution doesn't allow for a budget to be out of control. It's very specific in what should be allowed to be the taxpayers' money be spent on. And yet we already have this issue. What we need is to enforce our Constitution and its limits on power. And that's how we turn this situation around. It reminds me a little bit of a gal named Dorothy in A Land of Oz, how she went through this whole adventure, you might say, thinking that she needed the wizard to get home when she had the power in her ruby slippers the whole time. We already have the Constitution. That is our ruby slippers. That can get us home. One of our founding fathers said, the true constitutional use of correctional power is to inform and educate the people. That is what needs to happen. We need to make sure that people understand what our Constitution says, and the people will make sure that we uphold it. The people will ensure the term limits and vote the politicians that they don't agree with out of office, if that's what needs to happen. Another of our founding fathers said, neither the wisest constitution nor the wisest laws will secure the liberty and happiness of a people whose manners are universally corrupt. The Constitution is not the problem here. We have other work to do. Calling a constitutional convention is not going to fix the problem. On and against this bill.
Representative Swanitzer, do you have a motion for me?
Thank you, Madam Chairman. I move the Committee of the Whole Amendment number 1 to
Senate Joint Resolution Number 11 and ask for your favorable consideration. It's a pretty simple amendment. It just puts a sunset date on it as of January 1st, 2027. As I read through the bill, I had some constitutional issues if we can actually obligate the next legislature to have the same thoughts and feelings that we have in this legislature. But I went ahead and obligated them, but then the following one, it sounds like maybe it might be a good idea if we go back and have this discussion again in 2027 if this bill passes. I would ask for your favorable consideration. Thank you.
Any discussion on Committee of the Whole Amendment Number 1? Representative Singh.
Thank you, Madam Chairwoman. I would just ask for an aye vote on this amendment, and I support it. Thank you.
Question having been called on Committee of the Whole Amendment Number 1. All those in favor say aye. Aye. Opposed, no. No. The chair is in doubt. All those in favor, please stand. All those opposed, you don't need to stand. Less than 44. The Committee of the Whole Amendment Number 1 is adopted. Back on the bill. Representative Singh.
Thank you, Madam Chairwoman. So I just wanted to give you guys a couple of quotes. George Washington's farewell address. If in the opinion of the people, the distribution or modification of the constitutional powers be in any particular wrong, let it be corrected by an amendment in the way which the Constitution designates. But let there be no change by usurpation. For though this, in one instance, may have been an instrument of good, it is the customary weapon by which free governments are destroyed. And then President Abraham Lincoln, in his first inaugural address, said, this country with its institutions belong to the people who inhabit it. Whenever they shall grow weary of the existing government, they can exercise their constitutional right of amending it, or their revolutionary right to dismember or overthrow it. I cannot be ignorant of the fact that many worthy and patriotic citizens are desiring to have the national constitution amended. While I make no recommendation of amendments, I fully recognize the rightful authority of the people over the whole subject to be exercised in either of the modes prescribed in the instrument itself. And I should, under existing circumstances, favor rather than oppose a fair opportunity being afforded by the people who can act upon it. I will venture to add that to me, the convention mode seems preferable in that it allows amendments to originate with the people themselves, instead of only permitting them to take or reject propositions originated by others. Ladies and gentlemen, I bring this not to create division, but rather to address the issues that you and I are incapable of tackling on our own. We have before us the opportunity to embrace what our founding fathers have given us and unleash this check on the federal government built into our Constitution. This is a responsibility that was uniquely endowed upon us specifically and allows us to wield power that even the chief executive cannot hold. I believe that we have been endowed with reason and intellect to properly wield this power. Of the options before us, I would argue that this is the middle of the road. This is our chance to help continue the American experiment by intentionally righting wrongs. It is time to embrace our responsibility and equip the states with a voice that we may avoid another civil disaster and instead protect and preserve our Republican form of government. Please vote aye. Thank you.
Question being called. All those in favor of Chairman Harshman's, wait, what? Oh, Sorry, Representative Winter.
Thank you, Madam Chairman. In the words of a recently elected Congresswoman from Wyoming, the Constitution does not need to be fixed. The Constitution needs to be enforced. I'm against this resolution.
Question having been called, all those in favor of Chairman Harshman's motion that when the committee of the whole rises to report, it do so with the recommendation that Senate Joint Resolution 11 do pass. All those in favor say aye. Aye. Opposed, no? No. Senate Joint Resolution 11 has failed committee of the whole. Therefore, pursuant to House Rules 6-6B, having failed a voice vote, a standing division vote is required. All those in favor, please stand. Representative Western, are you on or off the floor? Thank you. Thank you. Opposed, please stand. More than 18. Having failed a standing division vote, a roll call vote is required. The chief clerk will call the roll.
Alaman? Allred? Andrew? Angelos? Banks? Bear? Berger? Brown? Burkhart? Byron? Chadwick? Chestick? Klauston? Conrad? Crago? Davis? Eklund? Haroldson? Harshman? Heiner? Henderson? Hornock? Jennings? Knapp? Larson Lloyd? Larson JT? Lawley? Locke? Nyman? Newsom? Nicholas? Nemec? Northrup? Oakley?
Aye.
Obermuller? O'Hearn? Olson? Ottman? No. Pendergraft? No. Penn? Provenza? Rodriguez Williams? Sherwood? Singh? Slagle? Smith? Stith? Storer? Strock? Stivar? Tarver? Trujillo? Walters? Ward? Washit? Western? Winter? Winter? Wiley? Yin? Swanenser Dan? Swanenser Dave? Speaker Summers? Are there any changes? Storer? Closing vote? Vote closed. 21 aye, 41 no.
Pursuant to House Rule 6-6B, Senate Joint Resolution 11, having failed a roll call vote, is indefinitely postponed. The next bill for our consideration is Senate File 127. The reading clerk will read the bill.
Senate File 127, sponsored by Blockchain, Wyoming Stable Token Act, an act relating to trade and commerce. Mr. Speaker, your committee number 7, Corporations, Elections, and Political Subdivisions, to whom is referred Senate File 127 engrossed, Wyoming Stable Token Act, respectfully report same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Chadwick, Harshman, Newsom, Olson, Wiley, Yin. Noes, Representatives Harrelson, Knapp, Ottman. Representative Olson, Chairman. This bill was re-referred to Committee Number 2, Appropriations. Mr. Speaker, your Committee Number 2, Appropriations, to whom is referred Senate File 127 engrossed, Wyoming Stable Token Act, respectfully report same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Swanenser. Representative Nicholas, Chairman.
You've heard the reading of the bill. What is your pleasure? Chairman Olson.
Thank you, Madam Chairman. I move that when the committee of the whole rises to report that it do so with the recommendation that Senate File 127 do pass. I further move the adoption of the standing committee amendment. And real quick, I'll just take up the standing committee amendment because it's really quite simple. All it does is delete the words "be prepared" on page 13, line 18, and insert "endeavor." And what we're talking about is the implementation of the Wyoming Stable Token. Instead of requiring its implementation by a certain date, which we all agree although we want it, maybe rushing it, that we simply adjust the language to endeavor to try to issue the Wyoming Stable Token by a date certain in the bill. And I'll take any questions on the standing committee amendment.
Any discussion on the standing committee amendment? Question having been called, all those in favor of standing committee amendment number 1 say aye. Opposed, no. The standing committee amendment number 1 has been adopted. We're back on the bill.
Thank you, Madam Chairman.
Please proceed, Chairman Olson.
And I would actually turn over the explanation of the bill to the good representative from the land of the Jagged Mountains.
Representative Yin.
Thank you, Madam Chairman. So I bring before you Wyoming Stable Token Act. Members, so for those that are new this year, this is a bill that actually passed out of our body this last year. So it was a bill that ended up getting vetoed by our chief executive, and he had some concerns over the administration of the bill. So over the interim, the Select Blockchain Committee worked to allay some of those concerns, and then also in our committee with both the standing committee amendment as well as the committee of the whole amendment, we're trying to work to allay those concerns from the chief executive even more. So members, to explain to you the concept of what a Wyoming Stable Token Act is and why the state of Wyoming should pass it. So there are 2 reasons. One, it helps facilitate commerce in the cryptocurrency space, in the crypto space overall, that Wyoming is already a leader in. So what the Wyoming Stable Token does allows for you to give $1 and then receive a Wyoming stable token that's pegged to the value of $1. It's pegged to the value of $1 because you can turn in your stable token at any time and receive $1 back. And so the question is, why should Wyoming decide to implement such a solution? There are private companies that are doing it. The issue with private companies is that no one knows whether they actually have the dollars because they're not audited in a way for you to be able to validate that they have the dollar to redeem back. The second reason that Wyoming passed it as well, and should pass it again, frankly, is that it will help us generate revenue income because all of the dollars that will be put in to the Wyoming stable token reserve account and trust fund account will build money because they'll be only invested in T-bills. And so T-bills are extremely stable form of investment to make sure that, one, we can show everyone in the world who wants a Wyoming stable token that they can redeem stable token and get back a $1 because the T-bills are not ones that drop in value. And two, we get to make money off of that investment dollar, which helps us make sure that we keep our taxes low for the rest of Wyoming. So the reason, the way that this would work is that when people give us their dollars and we issue them stable tokens, we invest all of those dollars in T-bills, we put it in a trust fund with a little bit of a reserve account to make sure that we can redeem things without having to liquidate the T-bills. But if we ever drop below a certain amount in the trust fund, we can't, in the reserve account, we can liquidate T-bills to also redeem that. And so you have that trust in the state of Wyoming to make sure that that money is there, as well as when we're talking about something that in the current market has a $100 billion cap, and you're making 2% interest on what the state of Wyoming could do, it's not only can fund the operation, but can be another revenue source for the state of Wyoming in the millions of dollars. And with that, I'm happy to answer any questions, but I can also go through the bill. But I think the first thing I will do is I will move Committee of the Whole Amendment number 1 to and talk about that, if I may.
Yes.
Or
please.
should we move with the second standing committee amendment first? So there is a committee, there is a standing committee amendment from the Appropriations Committee. Maybe we dispense with that first, and then I'll bring you back to the Committee of the Whole Amendment.
Chairman Nicholas, can you move Standing Committee Amendment number 2?
Maybe. It's okay. Madam Chair, I would move Standing Committee Amendment number 2 to Senate File 127. And I'll explain the amendment. Ladies and gentlemen, if you go to page 10 of the bill, you'll see that, when we drafted this bill before, we had high hopes that we're going to make a lot of money. And part of the process of this, and the reason why we're doing it, is because there was a market for this type of a stable token. And so what we did then, from our bill last year, we put the first $500,000 was going to go into the general fund, and then we divided the remainder up into 3 separate accounts. What we did in appropriations is we simply modified this so that all of the funds that we make will go into the school foundation program account. So it won't go into school permanent fund reserve account, by the way, which we just put a whole bunch of more money into, and that's our 5X. And then also we have the permanent mental trust fund reserve account, which we've also modified. So we thought it just made more sense to have the funds, if this makes money, to go into one place, and and a place that is more like a checking account, at least at this point, and then we can decide what to do with those funds. So we put it all into the school foundation program account, which is Wyoming Statute 21-13-306. So I ask for your favorable consideration.
Any further discussion on Standing Committee Amendment number 2? Question having been called, all those in favor say aye. Aye. Opposed, no. Standing Committee Amendment number 2 has been adopted. Back on the bill, Representative Yin.
Madam Chairman, so I would move Committee of the Whole Amendment number 1 to Senate File 127 and ask for your favorable consideration. So members, this was actually an amendment that was asked for by the Chief Executive's office. We were going to do it in the committee. The concern was that because it was our last committee meeting and we had to get it to re-refer to appropriations and have it come back, we would just draft it as a Committee of the Whole Amendment. So they're asking for these staff to make sure that they're background checked. And that's all this is doing, is just making sure the commission and the director and their staff have background checks.
Question having been called, all those in favor of Committee of the Whole Amendment number 1, say aye. Aye. Opposed, no. That amendment has been adopted. Back on the bill. Question having been called, all those in favor of Chairman Olson's motion that when the Committee of the Whole rises to report, it do so with a recommendation that Senate File 127 do pass. All those in favor say aye. Aye. Opposed, no. Senate File 127 is passed Committee of the Whole. Then, Mr. Majority Floor Leader.
Madam Chairman, I move the Committee of the Whole rise and report.
You've heard the motion. The body will stand at ease. The House will stand in recess for 15 minutes. Committee of the Whole come to order. Sorry, John. All right. Members of the House, you've heard the motion. All those in favor, say aye. Aye. All those opposed, no. The motion has failed. Division having been called, all those in favor, please stand. Thank you. All opposed, please rise. That, it doesn't matter. The motion has passed. 33-27.
The reading clerk will read the Committee of the Whole report.
Mr. Speaker, your Committee of the Whole, having had under consideration bills on general file, begs leave to report as follows. Senate File 72, due pass amended. Senate File 101, due pass amended. Senate File 167, due pass. Senate File 76, due pass amended. Senate File 120, due pass amended. Senate File 133, due pass amended. Senate Joint Resolution 11 failed to pass Committee of the Whole and was indefinitely postponed. Senate File 127, due pass amended. Representatives Oakley and Harshman, chairmans.
Chairman Oakley.
Mr. Speaker, I move the adoption of the Committee of the Whole report.
You have heard the motion. All those in favor say aye. All those opposed, no. Motion carries. Hey! The House will please come to order. Just a second. Messages from the Senate.
Message 439. Mr. Speaker, House Bill 123, collection of antler or horns by residents and non-residents. Upon reconsideration, the House bill listed above passed on third reading in an amended form as follows by the vote indicated. Ayes 16, noes 15. The Senate respectfully asks the House to concur by adopting the listed amendments. Message 434, Mr. Speaker, the Senate did concur on House amendments to the bill listed below by the vote indicated. Senate File 79, Plan of Safe Care Newborns, ayes 31. Message 435, Mr. Speaker, the Senate did concur on House amendments to the bill listed below by the vote indicated. Senate File 100, Designation of Spouses, Revocation upon Divorce or Annulment, ayes 24, noes 7. Message 436, Mr. Speaker, the Senate did concur on the House amendments to the bill listed below by the vote indicated. Senate File 169, State Shooting Complex Task Force, ayes 29, noes 2. Message 437, Mr. Speaker, the Senate did concur on House amendments to the bill listed below by the vote indicated. Senate File 116, Protection of Lawful Commerce and Firearms, ayes 30, noes 1. Message 438, Mr. Speaker, the Senate did concur on House amendments to the bill listed below by the vote indicated. Senate File 97, Education Trust Fund Transfer, ayes 31. Message 440, Mr. Speaker, the Senate appointed Senate conferees to meet with a like committee number 2 from the House on amendments to House Bill 14. The Senate conferees are Senator Case, Chairman, Senator Kolb, Senator Nethercott. Message 441, Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 11, State Park Rangers Retirement, ayes 29, noes 2. Message 442, Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 200, Non-Resident Hunting Licenses, Application Fees, ayes 19, noes 12. Message number 443. Mr. Speaker, the Senate appointed Senate conferees to meet with a like committee number 1 from the House on amendments to House Bill 144. The Senate conferees are Senator Boner, Chairman, Senator Case, Senator Schuler. Message 9. Mr. Speaker, the Senate has voted by a 2/3 vote of the membership to override the governor's veto on Senate Enrolled Act number 37, being original Senate File 71 by the vote indicated. Ayes 30, noes 1. The Senate respectfully asks the House to override the governor's veto on Senate Enrolled Act number 37, being original Senate File 71. Sincerely, Ellen Thompson, Senate Chief Clerk.
We're at that order of business of signing enrolled acts. The first enrolled act for our consideration is Senate Enrolled Act number 68. The reading clerk will read the enrolled act.
Senate Enrolled Act number 68, being original Senate File 97. An act relating to the Wyoming Education Trust Fund, repealing the Wyoming Education Trust Fund, repealing related provisions, providing for a transfer of funds from the Wyoming Education Trust Fund to the Common School account within the Permanent Land Fund, amending the distribution of trust funds available to public schools, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Senate Enrolled Act number 68, being original Senate File 97. I have so signed. The next enrolled act for our consideration is Senate Enrolled Act 69. The reading clerk will read the enrolled act.
Senate Enrolled Act number 69, being original Senate File 79. An act relating to public health and safety, requiring healthcare providers to develop plans of safe care for infants as specified, requiring hospitals to report to the Department of Family Services as specified, providing definitions, requiring rulemaking, and providing for an effective dates, being enacted by the legislature of the state of Wyoming.
I'm about to sign Senate Enrolled Act number 69, being original Senate File number 79. I have so signed. The next Enrolled Act for our consideration is Senate Enrolled Act number 70. The reading clerk will read the Enrolled Act.
Senate Enrolled Act number 70, being original Senate File 100. An act relating to wills and probate, specifying the revocation of probate and non-probate transfers to a spouse upon divorce or annulment, defining terms, specifying the role and use of governing instruments for revocations, repealing existing provisions concerning the revocation of transfers upon divorce or annulment, specifying applicability and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Senate Enrolled Act number 70, being original Senate File number 100. I have so signed. The next Enrolled Act for our consideration is Senate Enrolled Act number 71. The reading clerk will read the Enrolled Act.
Senate Enrolled Act number 71, being original Senate File 116, an act relating to civil procedure, providing immunity from the specified civil lawsuits to firearm manufacturers and sellers, specifying exceptions, providing definitions, specifying applicability, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I am about to sign Senate Enrolled Act number 71, being original Senate File number 116. I have so signed. The next Enrolled Act for our consideration is Senate Enrolled Act number 72. The reading clerk will read the Enrolled Act.
Senate Enrolled Act number 72, being original Senate File 169, an act relating to the administration of government, creating the State Shooting Complex Development and Oversight Task Force, providing duties of the task force, requiring reports, creating the State Shooting Complex account, providing appropriations, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I am about to sign Senate Enrolled Act number 72, being original Senate File number 169. I have so signed. Chief, does that clear the deck? Mr. Majority Floor Leader.
Mr. Speaker, I move the House adjourn until 10 a.m. tomorrow, the 28th day of February, 2023.
Any committee announcements? Chairman Eklund, Chairman Olson maybe, I think he's there quicker. Chairman Olson.
Thank you, Mr. Speaker. Your Joint Conference Committee on House Bill 14 will meet tomorrow at 12:30 in room 113.
Chairman Burkhart.
Thank you, Mr. Speaker. Your committee number 9, Minerals, Business, and Economic Development, will meet tomorrow morning at 8 a.m. to consider an interim topics with our counterparts from down the hall. We will be in room W113.
Chairman Eklund and Chairman Northrup, could you come up to the front, please?
Mr. Speaker, your committee number 5 will meet with our Senate counterparts to discuss interim ag topics at 8 o'clock tomorrow morning in our regular room. And then when we're done with that, probably around 9, we're going to do the Joint Conference Committee on House Bill 22, the cure process.
So that was a notice on Joint Conference Committee on which bill? On House Bill 22. Chairman Harshman.
Thank you, Mr. Speaker. Your Revenue Committee number 3 is going to meet with our Senate counterparts tomorrow at 8 a.m. to discuss interim topics. That meeting takes place in West Conference Room 6. Thank you.
Chairman Newsom.
Mr. Chairman, your committee number 6 will meet tomorrow at noon with our counterparts down the hall to discuss interim topics. Thank you.
Well, I guess Chairman Brown.
Thank you, Mr. Speaker. Your Joint Select Committee on School Facilities will meet tomorrow for our first quarterly meeting tomorrow upon adjournment. I do not know the room number, but it is posted, so I'll let everybody know that if you're so inclined to come watch an exhilarating committee meeting.
Chairman Northrup.
Thank you, Mr. Speaker. Your committee number 4 will meet with our constituents down the hall, and they're going to be, and we will talk about our interim subjects. That'll be on Wednesday at 8:30 in room 110W.
Any other committee announcements? I want to thank everybody here for keeping this got late, things are passionate. I think people did a really good job of maintaining the body in a civil manner, and I really appreciate all you've done to do that. And so with that, you have heard the majority floor leader's motion. All those in favor signify by saying aye. All those opposed? Motion carries. The House will stand adjourned until 10 a.m. tomorrow, February 28th, 2023.